Okay, we're going to go ahead and go on record. I've been advised we are already on record, correct? We are on record. This is the matter of State of New Mexico versus Alexee Trevizo, P503 PD 2023-00010. Once again, State of New Mexico versus Alexee Trevizo. Now, I'm going to let the parties know before we start that we are scheduled for a preliminary hearing and a pretrial detention hearing. I'm going to proceed with the pretrial detention hearing first. As both the attorneys are aware, pretrial detentions hearings do not, the rules of evidence do not apply to a pretrial detention hearing. I do not want a situation where we're having to bifurcate evidence as to whether it's admissible for one hearing or the other. So we're going to proceed with the pretrial detention hearing. Afterwards, we will proceed with the preliminary hearing at that point. I will also note that the defendant has not been arraigned. We're going to start with an arraignment on that matter, on this matter as well. For the record, will the parties please identify themselves?
Ariane Gonzalez, on behalf of the State of New Mexico.
Gary Mitchell, on behalf of Alexee J. Trevizo, who is present in the courtroom.
Okay. Mr. Trevizo, we are recording this. I can see you here. I see your attorney sitting next to you. But just for the record, will you state your name for the record?
Alexee Trevizo.
Thank you. Okay, we are scheduled again for a pretrial detention hearing. Again, as I mentioned, the rules of evidence do not apply. I do intend to impose the rule for today's pretrial detention hearing. I'm going to ask the state, who are the state's witnesses for this hearing?
Your Honor, I would actually ask the court if we can have these hearings concurrent pursuant to the rule. I don't have any evidence that wouldn't be admissible, no hearsay or things of that nature that would be admitted during the pretrial detention hearing. So I think it would be more the better use of the court's time to run them concurrently. I can mind the rules of evidence for pretrial detention.
Any objection, Mr. Mitchell?
There's no objection to that. That's what I anticipated we would do.
Okay. Then upon the stipulation of the parties, we will run these concurrent. So the rules of evidence will apply to this pretrial detention hearing / preliminary examination. Who are the state's witnesses?
Your Honor, the state will call Sergeant Xavier Anaya, Lori Aragon, Amber Bell, Cindy Buck, Elizabeth Crawford, Dr. Lauren Decker, Barnabas Gonzalez, Brandon Gottlieb, Hillard Halliday, Lila Lewis, Detective Jim Minter, Marina Perez, Rosa Rodriguez, Lorraine Romero, Erica Salas, Chris Sanchez, Dr. Haley Shinost, Dr. Heather Vasquez, Rick Wiedemann, and Officer Alexander Williams. All except, I believe, Dr. Decker, Dr. Shinost, and Dr. Vasquez are present.
Okay, I see a Dr. Vasquez on our Google Meet. I do not see any other of those names that you have mentioned on Google Meet.
Dr. Shinost is also on the Google Meet, Your Honor. This is Harley Shinost.
Okay, I see you. I see. Okay. Okay. So you have the two doctors on Google Meet. Okay. All right. If your name has been called as a witness, I'm going to ask you to stand and please raise your right hand. And those of you who are on Google Meet, I'm going to ask that you unmute your camera for purposes of the swearing in. Do you solemnly swear or affirm under penalty of perjury that the testimony you give here in court today will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, thank you. The court is invoking the rule, so at this time we will only be hearing from one witness at a time. What that basically means is that witnesses are not allowed to sit in and listen to each other's testimony. You're not allowed to discuss your testimony or the testimony of any of the other witnesses with each other until this hearing is concluded. So at this point, who will be the state's first witness?
Your Honor, the state will call Mr. Brandon Gottlieb. Okay.
I'm going to ask the two doctors on the Google Meet to please disconnect, and I'm going to ask all the witnesses to please wait out in the hall.
And Your Honor, for both Dr. Vasquez and Dr. Shinost, come back on.
Okay, let me check on that.
If I have phone numbers, cell phone numbers for both of you. If I don't, you can call my office and give them to Marley, and we can send you a text message to let you know to log back on.
Did you hear that, ma'am?
No, I'm sorry.
Okay, for Ms. Gonzalez, will you step up to the bench? I think she can hear better because that mic does not connect to our Google Meet. So,
I believe we have cell phone numbers for the both of you, but if we don't, if you can call my office and ask to speak with Marley and leave those for her, I will send you a text message when we log back on.
Marlene already has mine.
She has yours, okay. And Dr. Shinost, does she have yours as well?
I'm not sure, but I'll give them a call and make sure.
She had one that was on your CV. I'm not sure if that's current or not.
Yep, that's correct.
Okay, then we have it.
Thank you. You may both be excused. Before we proceed with the preliminary examination, Mr. Mitchell, your client has been charged with, let me pull up the, tampering with evidence and first-degree murder or in the alternative abuse of a child resulting in death. Do you wish to waive the formal reading of the rights and statute and on behalf of your client enter a plea?
I do, Your Honor. I've advised her of her constitutional rights and had a lengthy discussion with her. She understands would waive it at this time and ask you to enter a plea of not guilty to both counts.
Does either party wish to give opening statements before the preliminary examination?
I do, Your Honor, but it's not an opening statement. It's a matter of evidence.
All right. You may proceed. Ms. Gonzalez, you'll get a chance to respond, but go ahead.
One of the witnesses I called, Ms. Rosa Rodriguez, was not in the courtroom, so our investigator went to go get her so that she can be sworn in.
Okay.
Okay.
So in the evidentiary matter you wish to raise, sir?
I do, Your Honor. Before we start, and I don't know, in this courtroom, sometimes they want to sit at the tables, but if this is
That's fine. That's fine.
That's fine. Your Honor, this case, as the court is going to find out, and from reading the complaints you already know, took place in Artesia on January 26th and 27th at the Artesia General Hospital. And in December 15th, I believe it was, of 2022, our Supreme Court came forth with an order regarding Rule 11504, which is the physician-patient and psychotherapist-patient privilege. They modified that to a certain extent. And that rule applies to this case, we believe. In fact, this case is centers around that problem, and that issue runs rampant through it. So the rule requires that the privilege be claimed by the patient, and in this instance,
I'm going to stop you, Mr. Mitchell. Ma'am, can you have the witness just, I'm going to have you wait outside the door, and then we'll bring you in to swear you in as soon as we're ready. Go ahead.
As I indicated, this case is rampant with issues regarding the privilege because she was at the hospital, went to the hospital for care, and if you take a look at that rule, the premier case of that rule is a case out of the 12th Judicial District called State v. Roper, and it's expanded to include testing and this sort of thing as well. In that case, it involved a blood test that was held to be under the privilege. So, and the case law is such that the defendant in this case, or the patient, has to raise the privilege, and we assert the privilege. And I'll explain in just a minute what else that means. Furthermore, Artesia General Hospital is a hospital that receives federal funding and therefore is a covered entity under the Health Insurance Portability and Accountability Act of 1966, known to all of us in the hospital world as HIPAA. And that privacy rule sets forth standards for use and disclosure of individuals' health information. And the reason I say it's a covered entity is because I know that they receive federal funding under Medicare and Medicaid. They couldn't operate in New Mexico if they didn't receive that, frankly. There may be a private hospital, but they receive funding from that. They also receive funding under the Hill-Burton Act, and therefore they're subject to HIPAA, which means all of this information, all of these medical records, this videotape that the first witness is going to address, all these communications with doctors, by my client, their patient at the time, are all protected under the privilege. This case is rampant with that. And frankly, there are so many HIPAA violations under the federal act that it's difficult to keep track of them or to count them up because they They never got consent from my client to disclose this stuff. They never got consent from me to disclose any of it. They didn't get consent to talk about what information she may have given them or may not have given them, or the tests that they ran. So this case is replete with this issue. And I bring it up now so that the court, we can either discuss it, argue about it. If the court rules that it doesn't apply, I'd like a continuing objection, so I'm not constantly standing up to almost every witness, particularly if they were a doctor. This does not apply to OMI, I'll tell you right now, also to the medical investigator, nor to the toxicologist that the state may call. I understand that. But the information they may have received from Artesia General Hospital, from the emergency room doctor there, and or from nurses or other staff, are all covered by the acts. Either one, the Federal Act of Privacy, which controls as well, or more important, the privilege in New Mexico under the physician-patient privilege. So the court is, anyway, I've made the point. And frankly, I know that we not only have a videotape taken that comes from the hospital, but we also have witnesses that are going to talk about all the tests and everything they ran. Plus, they're going to talk about conversations with my client and what information she may have given them. She went to the hospital. The whole event occurs at the hospital. She was admitted to the hospital at 5 minutes after midnight on the 27th day of January. And the tests and conversations took place after that. Thank you, Your Honor.
Ms. Gonzalez.
Quoting there, sorry. Your Honor, this is a significant motion that I had no knowledge of beforehand, so I don't have case law or haven't fully read the Roper matter. However, I'm a little, I don't understand, is this a motion to exclude or just a continued objection to the testimony of all the witnesses? I'm not clear what remedy is being sought this time.
I can
Please.
straighten that out. The remedy is one of forebodings and exclusion, meaning they're not allowed to testify when there's a privilege as to what they discussed with my client, her conversations with them. They're not allowed to discuss tests they took from her or information that they received either through lab tests or through a physical examination or internal examination, as is conducted in this case as well. They're also not allowed to provide videotape or whatever of what the hospital may have done. Now, what police officers do later on, what they may have taken is fine, except they didn't have a waiver of the privilege when they interviewed these employees of the hospital. Therefore, that's excluded because we assert the privilege to that. The same thing for the emergency room doctor, the emergency room nurses, the triage nurse, all of whom have been called in this case. And it goes even to housekeeping and this sort of thing under HIPAA and the physician-patient privilege. And Roper says, hey, these test results are out as well. They're privileged as well. But the state has a tremendous problem in this, and it's one of exclusion and one of you can't get into it. So that's the situation we find. Now, I'm an officer of the court. I'll tell you that the state's argument should be that we assert there was a crime committed at the hospital. Therefore, that is not within the privilege we should be able to talk about. That means OMI can talk about what they found in an autopsy. The toxicologist can testify, since they are looking at what may or may not have been with the baby as to the toxicology results, and there's 2 labs that are involved. That's the situation, but the rest of them are all privileged. So I don't know how you get to first base without violating the privilege which we assert. It's something that needs to be looked at. in detail. And I apologize to counsel, but here's the situation, and counsel knows this. I was in court yesterday in Roswell, got back to my office, found where we had disclosure of voluminous documents. I spent most of the night going through all of these documents and making notes on them, and including police reports of interviews with hospital. Is that me? So, hospital personnel. It's just a loud boom like we have a band in here. Including hospital personnel. So keeping all of that in mind, and this type of case is rare. I mean, it's rare to the point that we have this in DWI cases and sometimes in drug cases where we're talking about tests done by hospitals, like Roper talks about. But we've never had a case where we have a patient in the hospital who's there to get care, and then we have these results, and then we have criminal charges flowing from it. That is a unique situation that the court's going to have to struggle with, and I think both attorneys are going to have to struggle with. But I bring it up only because I got all this information. I would have drafted something, but frankly, there comes a point in time you better get a little sleep before you get on the road.
Thank you. Having heard this motion and argument from the parties, the court is basically going to describe this hearing today. As you're both aware, we are here for preliminary hearing, and this is normally not how we would have conducted this. Up until recently, the procedure would have been that this case would have been filed in the magistrate court, and the magistrate court would have determined whether or not probable cause existed to have this matter bound over. A preliminary hearing, two things must be proved during a preliminary hearing. The fact that a crime has been committed and that there is probable cause to believe that the person charged committed it. This is State v. Vallejos, 1979, NMCA 089. In this particular hearing, I believe I am in a very unique situation. As you're both aware, I am a former magistrate judge myself, and this takes me back to my role as a magistrate judge conducting this preliminary hearing. And one of the restrictions on a magistrate judge conducting a preliminary hearing is we did not rule on evidentiary issues in a felony case during the preliminary hearing. That is something that we would simply have to be addressed in the district court after the preliminary hearing. And I believe that my role today in conducting this preliminary hearing is identical to my role previously as a magistrate conducting a preliminary hearing. So ultimately, I am not denying your motion, Mr. Mitchell. I believe it is not timely. I believe that for purpose of the preliminary hearing, this court cannot address evidentiary issues during the preliminary hearing. You certainly have the right to raise this issue in a written motion after the preliminary hearing if we get to that point. But for purposes of today's hearing, this court will take your motion under advisement, but will not grant the motion at this time.
And I understand. I thought the court might reach that analysis, and you're pretty astute. You are. I appreciate that. So, but just know that the case law and the rule requires that I have asserted it.
Yes.
And I didn't want to waive that.
Understand, sir.
All right. Thank you, Judge.
Thank you. Okay, before we start, I don't want to forget this. The state will call in their witness who has not been sworn in, and I will get that taken care of, and then we can proceed with opening statements. That's okay. Alexee, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you give here in court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may step out, ma'am. Does either party wish to give opening statements?
Not the state, Your Honor.
No, Your Honor.
State may call their first witness.
Your Honor, the state will call Brandon Gottlieb.
Yes, sir. Please grab a seat here in the witness stand.
May I please the court?
You may proceed.
Thank you. Sir, will you please state your name for the record?
Brandon Gottlieb,
And Mr. Gottlieb, where are you employed currently?
Artesia General Hospital.
In what capacity are you employed with the Artesia General?
I'm the facilities director and also the security director as well.
Facilities director, and you said security director?
Yes, ma'am.
As your duties as a security director, what do they entail?
So we have a security guards on there that I manage on there that we have on site 24 hours a day, 7 days a week. We also manage the security cameras, pull footage when we need to on there, and monitor all badges and door access throughout the facility.
So you said you monitor, one of the things that you do, you monitor the security cameras.
Yes, ma'am.
Are there security cameras throughout the Artesia General Hospital, or are they in a specific area?
They're all throughout the facilities.
And how does, or can you explain for us how these cameras capture videos or?
So they're motion activated on there, so anytime they detect motion, they start recording any video footage at that time.
Is this true for all cameras or just certain cameras?
All cameras.
And so once they're activated in motion, how long do they remain recording before they stop or deem there's no one else?
I believe it's about 15 to 20 seconds after it stops detecting motion that it'll drop that camera footage on there, and then as soon as it picks it back up, it'll start recording again.
And there's another motion.
Correct, I believe.
Is there any way that these can be switched from motion detection to just general recording?
No, ma'am.
They're all motion detected?
All motion,
all the time?
correct, yes, ma'am.
And so once a camera captures a recording, regardless of where it is, how do those recordings get stored?
So it gets stored in our server on there that our IT department manages, and it keeps it on hand for 90 days, and then it deletes the oldest footage.
How many videos?
90 days.
90 days. 90 days, and then it deletes the footage.
The oldest footage, yes.
So within those 90 days, can someone come in and ask, say, can you give me the recording from the 33rd day?
Depending on who the individual is at that time, and I also ask for approval from our administration too, on who I directly report to.
Depending on who and get the approval from
Approval, correct, yes.
And how would you go about, let's say you did get the approval that you needed, and it was a person who was appropriate, how would you go about getting that individual a copy of the recording?
Typically, we'll work with them and see, like for this case with the police department, they send me a private link for me to upload the footage to them and send it to their evidence database.
For the police department, for example, they send you a private link, you upload it to that, and it's basically sent or...
Correct.
Mr. Mr. Gottlieb, were you employed with the Artesia General Hospital as the security director on January 27th, 2023?
Yes, ma'am.
And on or around that date, did you get a request from the Artesia Police Department for footage from the emergency room?
Yes, ma'am, I did.
And did you provide the Artesia Police Department with security footage?
Yes, ma'am, I did.
And do you recall from, let me withdraw that. Are there different, for the emergency room, since that's what we're talking about, are there different cameras that are located in the emergency room?
No.
There's just one?
There's multiple cameras throughout, but they're all the exact same style.
The same,
Same type of camera.
same type? Okay.
Yes.
Sorry, I'm having a little bit of a difficulty hearing you. Mr. Gottlieb, I'm going to show you what's being marked as State's Exhibit 1 for purposes of identification. May I approach the witness?
You may. That's mine, yeah.
Yeah. The only objection I have is, it's what? Oh, no.
It's 2 hours, but I'm not going to play the entire.
Okay. Your Honor, just as my continuing objection, but I don't have another objection.
Noted.
A few minutes of this. So look at it.
Okay.
Shouldn't be. It's pretty bad stuff. Depending on what they found. They can have some privacy. They may find out, geez, everything you're doing is valid. Supposed to be coming. Is that State's Exhibit 1? Okay.
Mr. Gottlieb, do you recognize what's showing in the video that I just presented to you?
So that's showing our ER department, and it's showing the hallway that leads to the restrooms.
Okay. Inside of the ER department, the hallway that leads to the restrooms.
Yes, ma'am.
And is this the footage that you disclosed to the Artesia General Hospital on or around January 27th?
Yes, ma'am.
Does it appear to depict anything other than the Artesia General Hospital emergency room on that day?
No, ma'am.
Your Honor, I'd like to move State's Exhibit 1 into evidence and publish a portion for the court.
Your Honor, I made my objection, though. Thank you.
Objection noted and overruled. You may proceed. And for the record, State's Exhibit 1 is admitted.
Most familiar with the courts. There is no audio, there's only videos.
Is this going to come on our computers? Is this going to come on our computers? Let's see if it's coming. I'm not seeing anything. Yeah, I'm not able to see it on my computer, on my screen. Let me see if it will come on here. Here we go. This might do it. Is it coming up on your screen?
No, sir.
No, it is on the.
I see it on that screen there, but I don't see it on any others.
These may not be on. I don't think it's on. I'm not sure if you do that from the outside or if there's.
Should be a power button. Officer, can you see if there's a power button on your side? So the zero's on?
I'm trying it right now.
I can provide my laptop. I said, so please wait.
I don't think that was connected to the, that was like the video on everything. I don't think that's connected to the system. That's a separate.
It's usually this one.
See if I can, I've got some sort of control panel here, so let me see if that,
No, this one came on.
Does that normally depict on these? It's on now. It just says no signal.
I guess if Danielle can come in, maybe she can you IM Danielle, see if she can come in and get this, has anything come up?
No, sir.
Well,
It's the one on the bench.
I guess they didn't leave any instruction. Jennifer said that it's supposed to be set up the same as courtroom one, but they bring their own audio cable.
okay, so we don't have an audio cable.
No, sir.
All right, Ms. Gonzalez, apparently there's going to need to be a separate audio cable for this. Now, I can see the screen. If you want, I can come closer. I've got no problem with the witness stepping up to the edge of the table to look at the video that way, but you're going to need to provide a separate audio cable. I've been advised by the bailiff that that's generally how we do it.
It's connected here, but there isn't any audio. This is just, it's just.
Okay, so,
And Judge, I have absolutely no objection to doing that. The court's solution is good.
okay. Well, I'm going to watch it from here then, and if you can't see it, that screen right over there, you're welcome to step
Okay.
up to the table.
I can see it from
Okay.
here.
I'm just going to ask Mr. Fitzgerald if you can just lean back a little bit. Thank you. You may proceed, man.
Your Honor, I'm going to start it at minute 7, approximately 45 seconds. Or as opposed to 40 seconds.
The top left corner.
I'm going to stop that there at minute 26:20. Mr. Goddard, one last question. Do the videos that are recorded in the Artesia General Hospital, are they time and date stamped?
Yes, they are.
Where is that? I know we're having some difficulty. Are you able to see where in the video that shows?
The top left corner.
So the top left corner.
It should show the time and date.
And to your knowledge, was that accurate on this day, January 27, 2020?
Yes, ma'am.
There are any further questions
Mr. Mitchell?
Thank you.
Am I correct that the bathroom that's depicted in this videotape is a communal bathroom in the ER?
Yes, sir.
It's not in an examining room.
No, sir.
It's in the hallway of the emergency room.
Yes, sir.
Is that the only bathroom in the ER?
No, there's one right next to it, but it's a staff restroom.
So you have a staff and then,
And a patient, a patient restroom.
okay. But the public bathrooms in the emergency room of Artesia General Hospital.
They are in the hallway, in the emergency lobby.
And did you happen to time when Alexee went into the bathroom and when she came out, did you have to time that?
I believe it was 19 minutes.
Or 18 minutes? You went in at 0139 and came out at 157?
Potentially, yes, sir.
All right. Thank you.
Anything further for this witness?
Just a clarifying question. Mr. Mitchell asked you about the public and not private, but ER bathroom. So, just for clarity, the bathroom that's depicted in this video, if I were to walk into the emergency room from the street, would I be able to access that bathroom before being admitted or taken back to?
No, ma'am.
So this is strictly for patients within either admitted or housed in the emergency room.
Yes, ma'am.
Is there a separate bathroom for the public? Say I did walk in off the street, would there be someone who would use the restroom when I check in or at the entry?
Yeah, there's one in our main lobby.
In the main lobby?
Yes, ma'am.
Thank you. I don't have anything further. And he would be able to-
Any objection, Mr.
No
Mitchell?
objection.
Sir, you've been released from subpoena. What that means is you're no longer required to stay. You're not going to be called back as a witness. You may go about your day. Thank you.
Your Honor, the state's next witness will be Christopher Sanchez.
And Mr. Sanchez, I'm just going to confirm you were sworn in, correct? I know I swore in a lot of people at once, so I just wanted to make sure. Thank you.
May I please report?
You may proceed.
Sir, please state your name for the record.
Chris Sanchez,
And Mr. Sanchez, where are you employed?
Artesia General Hospital.
In what capacity are you employed with the Artesia General Hospital?
I am a registered nurse in the ER.
Mr. Sanchez, were you working on January 27th of 2023?
I'm assuming that's the night that we're here for, and yes, but I don't know what date that was. Sorry.
You're unsure?
I'm unsure of the date. Yes.
So I'm going to take you back to a date in January. Were you on shift and there was an incident that required law enforcement to come out and investigate?
Yes, I was.
Was that situation regarding a newborn infant?
Yes, ma'am.
What, I know you said you were an RN in the emergency room. On this date, did you have a specific task or area that you were assigned in the ER?
Yes, I did.
What was that?
I believe I had rooms 2, 4, and trauma 2.
It was 2, 4, and trauma 2. And so how do you get assigned, or when you come to work that day, is that already designated for you? Or
It's designated, yeah.
on that date, Mr. Sanchez, did you interact with an individual named Alexee Trevizo?
Yes, I did.
And was she in one of the rooms that you were assigned?
Yes, ma'am.
Do you see Ms. Trevizo in the courtroom today?
Yes, I do.
Can you point her out or describe what she's wearing for the court, please?
Yes, she's wearing blue Oh, coveralls and glasses, black hair.
And does the record reflect that the witnesses identified the defendant, Alexee Trevizo?
The court will note that the witness has identified the defendant, Alexee Trevizo.
Mr. Judge, do you know if you were the first person in the emergency room to make contact with the defendant that day?
Possibly the first nurse. I believe I pulled her into the triage room.
Possibly the first nurse who pulled into triage. What's triage?
I'm sorry?
What's triage?
What's triage? It's just a room to designate acuities of the patient and kind of to do an introduction, vitals, and then get her into an emergency room in the back.
It's a step before getting
Yes,
her
ma'am.
into a patient room. And what was the defendant there for?
I believe it was back.
Your Honor, I'd like my continuing objection.
Noted.
Thank you.
Overruled.
I believe it was for back pain, lower back pain.
And so, you said earlier the triage rooms for vitals and things of that nature. Did you get all of those things done on the defendant?
I possibly did. I honestly do not remember if we were able to obtain all of the vitals in that room or if we got them in room 2, which is where I placed her.
Okay, so you either got him in the triage room or in room 2?
Yes, ma'am.
But you're not sure which?
Correct.
Okay, I understand. Mr. Sargent, was anything else reported to you other than the lower back pain?
Not that I recall.
Sorry, I should have clarified that. Any other medical issues that were reported?
Not that I recall.
Did something happen that caused the defendant to leave room 2?
I'm not sure what you mean.
I can rephrase. Did the defendant ever leave room 2?
Yes, she did.
Okay. Where did she go?
To use the restroom.
What restroom did she go use?
The ER patient designated restroom.
So in the emergency room in the RTJ, is there, in the patient room in room 2, is there a separate bathroom in room 2, or is it in another area of the emergency room?
It's in another area.
Can you describe where, in reference to room 2?
It's almost directly down a straight hallway, but there is a slight curve. It's just right down the hallway.
And you said that this is an ER patient designated restroom. So does this mean that can members of the public use this? Let me rephrase that. Members who are not in the ER use that bathroom?
Visitors will also use that restroom.
Visitors will?
Visitors with patients.
Okay, visitors with patients.
Yes.
So the defendant had to use the patient bathroom. Was there any issue at that point that you saw or anyone else saw with her going to use the bathroom?
No, ma'am.
Did an issue arise once the defendant had gone to the bathroom?
Yes.
What was that?
So the ER doctor wanted to examine the patient, and she had been in there for an extended period of time. So I went to check on her, and several times, and she said she was coming out, but remained in there for a bit longer until I asked for our clerk to get the keys to unlock the door, and then she finally came out of the restroom.
Okay, so doctor wanted to examine her, and you said the defendant had been in there for an extended period of time. Can you give us an estimate or a description, best you can, as to what you mean by extended period of time?
Maybe 15, 20 minutes or so until,
Before the clerk came with the key?
before I went to check on her, and maybe about, yeah.
I'm going to show you just a still of what's been entered as State's Exhibit 1. This is 2621. Is this you depicted in the still? Can you see? And if you if you can get up and look if you need to.
That is fine.
It looks like,
Fitzgerald, can you lean back again? Thank you.
yes, it looks like, yes.
And in this still, can you see where the ER patient bathroom is?
Yes, it would be directly over my left shoulder, near the fire extinguisher on the wall.
Directly over your left shoulder, and you said near the fire extinguisher on the wall?
Yes.
Okay. Is there anything else near the door other than the fire extinguisher?
There's a drinking fountain.
So this area here.
Yes, ma'am.
And is this the bathroom that the defendant was in?
Yes, ma'am.
So you said you checked on the defendant multiple times. You said she was coming. Were there ever anything that you heard that caused you to think that the defendant needed help or assistance?
I just heard the paper towel dispenser dispensing paper towels several times. I don't know how many times, but it was more than I would expect a normal person would need to wash their hands.
Okay. So that was the only sound that
Yes, ma'am. That was the only sound.
When the defendant came out of the bathroom, where did she go?
She walked directly back to her room, bed 2.
Did you notice anything about her that was different when she walked out of the bathroom?
No, I don't believe so.
Was anything reported to you by the defendant when she walked out of the bathroom?
I asked the patient what had happened because I saw the bathroom when she opened the door, and I asked her what happened, and she says, "I'm on my period." That was the only thing she reported.
What prompted you to ask what happened?
There was a large amount of blood on the floor and the wall behind the toilet.
Floor, and behind the toilet, and the ER patient bathroom?
Yes, ma'am.
If I may approach the witness and post mark the State's Exhibit 2 for purposes of identification.
I've seen it.
Mr. Sanchez, do you recognize this photograph?
Yes, ma'am, I do.
Okay. And what is depicted in this photograph?
It appears to be the restroom, the patient restroom in the ER department.
And does this photograph accurately depict what you just described to us, this blood being on the floor, on the walls?
Yes, ma'am.
And this was after the defendant exited the bathroom?
Yes, ma'am.
Does it look to have been altered or changed in any way that you saw it that day?
Not that I can recall. It was...
Your Honor, I'd like to admit State's Exhibit 2 as evidence.
Just my usual objection, but otherwise none.
No, objection is noted. State's Exhibit 2 is admitted into evidence.
Really use it for questioning. Sergeant, to your knowledge, did this bathroom, was it in this state prior to the defendant going in?
To my knowledge, no, it was not.
There is something that's on the wall in that photograph that has a long string coming out of the bottom. And I can, if you need to photograph it, then I can get that to you.
The call light, it would be a blue string. Patients pull it to if they need assistance.
Okay. So you said it's a call light?
It activates the light outside of the restroom if they pull that string.
So it's a box with a long blue string, and you said patients pull it and it'll turn on that light outside of the bathroom?
Yes, ma'am.
Does it alert anything, any other way other than turning on that light?
Yes, there is a bell or a chime that lets the staff know that someone needs assistance.
While you were, well, the defendant was in the bathroom, did that light or chime ever get activated?
The light never went on and the chime never went off. No, ma'am.
So, Mr. Jones, when you see the bathroom in this state, you go inside to inspect further.
Yes, ma'am, I did.
And what did you inspect when you went inside of the bathroom?
I looked into the toilet and also looked into the trash liner.
Okay. And did you see anything in the toilet?
No, not that I recall.
And you said you looked into the trash liner. Did you see anything in the trash liner?
No, ma'am.
There's a trash can depicted in State's Exhibit 2. Is that the only trash can that was located in that bathroom?
Yes, ma'am.
So, once you looked at that, you got the defendant's answer about why the bathroom was in that state. What did you do from there?
I don't recall exactly. I would have most likely went back to the nursing station and let the physician know that there had been a large amount of blood in the restroom.
Or the amount of blood?
Yes.
Just as a matter of course, if your facility anywhere, the bathroom, the hall, patient room, do you leave it in that state, or do you usually call someone to come in?
We call, they call them EBS, it's Environmental Services, and they come in. They'll get a deep clean.
I'm referring back to the still frame in State's Exhibit 1. Can you see where the nurse's station is located in this?
Yes, ma'am.
Where is it located?
The way that I am facing right around that corner.
Right around that corner. So there, it looks as though someone or something red is there in the bottom right-hand corner of the still. Can you see that? I'm so sorry.
Yeah, I can't make out what that red is, though, but yes.
But is that the direction that
Yes,
you're
ma'am.
going to? Okay. So you said in the trash can, there was nothing that you saw inside of it. Does that mean nothing of concern or nothing at all?
I don't recall it having anything in the trash liner.
Not even any trash?
Correct.
Was this the last contact that you had with the bathroom in reference to the defendant?
I believe so, yes.
You didn't go in there again after inspecting the bathroom?
I don't believe so.
Did you continue to treat the defendant, or did someone else either take over or?
I believe I may have given further medication at that point, but we kind of assisted each other in treatment at that time.
Can you describe the defendant's demeanor while she was in your care or in the care of Housekeeping General Hospital?
Objection. Her demeanor is irrelevant. Actually, she's there for medical care.
Your Honor, I don't believe demeanor is ever irrelevant from whether she's there for medical care or not. That can be argued and inferred. The court can consider that.
Objection overruled. You may continue.
Is that-
Objection overruled. You may answer the question.
Thank you. What was her demeanor like?
Initially, when I took her into triage, she seemed very uncomfortable. And then shortly after, she seemed to kind of start feeling a bit better after being in room 2 for a little while and had received some medications. So she appeared much better than when she first arrived.
Uncomfortable to start, then once interventions, medications, she seemed to get better.
Yes, ma'am.
Did you make any other observations about her?
Not that I can recall.
Was she there alone?
No, ma'am.
Who was she with, do you know?
She said it was her mother. Mother was with her.
All right, that's all the questions I have for you. I'll pass the witness.
Mr. Mitchell?
Thank you, Your Honor. Mr. Sanchez, as I understand it, she was admitted to Artesia General Hospital at the emergency room at 5 minutes after midnight. Is that correct?
I'm not sure. I'd have to look at the charting to know the exact time.
But best to your recollection, that's approximately correct.
Objection. It's asked and answered.
I'm sorry?
It was asked and answered.
I'll allow the question.
Go ahead.
I honestly do not know what time it was.
All right. You haven't examined any medical records?
No, sir.
So you're doing all this from your recollection?
Yes, sir.
All right. Well, is it true or untrue that when she was in the ER room, that at some point in time she was given medication?
Yes, sir.
Do you know if that medication was given via an IV?
I believe it was given IV, yes, sir.
Okay. And was that medication given at approximately 18 minutes after midnight?
I am not sure about the time, but shortly after her arrival, we would have given it.
Was the doctor on duty that night, Dr. Heather, and I don't know how she pronounces her last name, Vasquez?
Vasquez, yes, sir.
Is that the doctor that was the attending physician?
Yes, sir.
Do you recall, prior to receiving medication, if the attending physician ever came in and did any type of cursory examination?
Yes, sir. The doctor was present in the triage room before we moved her.
All right. So it would have been the doctor that ordered the medication?
Yes, sir.
I mean, you wouldn't have ordered the medication,
No, sir.
not within your skill set.
Not within our scope. Yeah.
Okay. So, do you recall that she received medication, sodium chloride, ketorolac, Zofran, morphine, sodium chloride, and at least that?
I would have to review the chart, but it sounds accurate.
All right. Most of those are pain medications, are they not?
2 of those are pain medications.
Okay. Now, were you present or did you attempt to get a UA?
I don't know who received a UA, but I know we did receive a UA. But
Did not?
I don't know if I received it or if another staff member collected it, but we did.
Okay. Did you also take a blood test?
Yes, sir.
You call in a phlebotomist and take blood.
I believe I would have drawn the blood at the same time I started the IV catheter.
Okay. And did you order a pregnancy exam?
I personally didn't order it. The physician would have ordered it.
But did you, at 28 minutes after midnight, get an order for it, collected at 30 minutes after midnight, send it to the lab at 31 minutes after midnight, and get a report back at 51 minutes after midnight?
I would have to look at the chart for the exact
But that
times.
sounds pretty classic, doesn't it?
The time frame doesn't sound off.
Okay. So let's talk about this pregnancy test, because the medical records in this case indicate that you received information that 51 minutes after midnight that she was in fact pregnant. So you recall that?
I do not recall it, but usually the lab will call us for that positive test.
And that was before she ever went to the restroom.
I'm not sure of the time frame, but it could have been. I'd have to look at the time.
Now, you would not have told her she's pregnant. You would have given that information to the treating physician. Is that correct?
That's correct.
And would I be correct that from the time Artesia General Hospital found out that she was pregnant at approximately 12:51 in the morning, that it was 48 minutes before she went to the restroom?
I do not know the time frame of that.
Okay, but that's what the videotape and the medical records indicate. You wouldn't dispute that now, would you?
No, I wouldn't.
Would you agree with me that before she entered the bathroom, medication had been given to her through an IV?
Yes, sir.
Somebody had to help her unhook that IV.
Yes, sir.
She was complaining at that time, in order to get the IV unhooked, that she had to go to the restroom,
Yes, sir.
and that she was desperate to go to the restroom. In
I,
other words, she felt that she couldn't control it anymore.
I'm not sure if that was reported or not.
Okay. But at that time that the IV was being unhooked, the doctor had not come back in the 48 minutes and told her or indicated to her that she was in fact pregnant, had she?
I'm not sure.
Did anybody do an exam? Well, let me ask you this. The court has seen the videotape, and you can see part of the videotape. She was not in a hospital gown at the time she went to the restroom, was she?
No, sir.
She had not been placed in a hospital bed at that time, had she?
What's that, sir? I'm sorry.
Before she went to the restroom, she was still in civilian clothes.
She was still wearing her clothes, yes, sir.
Now, as I understand it, that means whatever period of time that was, that none of the nursing staff would have told her she's pregnant. You left that to the treating physician only. Is that correct?
That's correct, yes, sir.
And the treating physician, where was she during that 48 minutes?
I don't know. Probably, I'm assuming sitting at her designated desk, but I don't know where she was.
Well, would you, being a good RN, have noted and have alerted the doctor to the fact that you had a female of childbearing age in the emergency room complaining of abdominal pain and complaining of back pain, flank pain, that you had just got a pregnancy test back from the blood test that indicated she was pregnant? Would you have alerted the doctor to that?
Yes, sir.
Wouldn't she also receive the same information if you guys are in compliance with the Affordable Care Act and the computer systems you're supposed to have? Wouldn't you and the doctor simultaneously, since she's an emergency room physician, treating physician, have received that report from the lab?
I don't understand your question.
Well, after the Affordable Care Act, all these hospitals were required to have a computerized system so that we could transfer this information instantaneously to the people that needed to have it in the hospital. I assume Artesia General has that system in place.
Yes, sir. The lab report is also put into the system at the same time.
Right. And since The doctor should have received by 00:51, 51 minutes after midnight, the report that Alexee was pregnant, just as you received it. Is that correct?
On the system, correct.
Okay. Now, you've been in an emergency room nurse long enough to know that when you have a female that's pregnant and all of a sudden she feels the urge that maybe she has to go defecate, that may be something that you ought to check into to make sure she's not delivering a baby. Right? Classic symptom. Correct?
I did not know how far along she was, and she adamantly denied to me that she was sexually active.
Well, I appreciate it, but you had a test that you felt, I know what's causing that noise, that's me. You had a test that said that she was pregnant, a test that you put great reliability in. Is that correct?
That's correct.
Mr. Mitchell, I'm going to stop you here. Let's take a short five-minute recess here.
Oh, sure.
Or let's make it about 5-10 minutes. Does anybody need a bathroom break or water break or anything? Okay. All right, we'll make it 5 minutes then. We'll reconvene in just a few moments. All right, we're back on record on D503 PD 2023-00010, State of New Mexico versus Alexee Trevizo. Mr. Mitchell, you may continue.
Thank you. Now, we were talking about a symptom that because you knew at 12:51 that you had a test, blood test, that she was in fact positive pregnant. That you and the doctor both had, but yet she's allowed to go to the bathroom at 1:39 in the morning.
Yes, sir.
Now, knowing that she's pregnant, does Artesia General have an OB ward?
No, sir.
Does it have an OB wing?
No, sir.
Does it have anybody you call in case you have somebody that's pregnant in a hospital?
No, sir.
I'm sorry?
No, sir.
No. Okay. However, the emergency room physicians are supposed to have some knowledge of how to deal with somebody that might be pregnant, correct?
Yes.
Okay. And one of the primary symptoms you have with a woman that's pregnant is if she feels that like she has to go to the bathroom, it may be that that's a pretty good idea that you check to make sure that she's not trying to deliver a baby rather than to have to go defecate. Is that correct? Does that make sense?
It's possible that, yeah.
Now, the medical records indicate in this case that you had that information for 48 minutes before she went to the restroom. The fact is, she was still in civilian clothes. Nobody had placed her in a gown appropriate for an examination, a pelvic examination, have you?
No, sir.
So, and that would routinely follow if you have somebody that's pregnant and you don't have the results back as to how close to date of delivery she may be, that perhaps further examination, physical examination is necessary, correct?
The doctor makes that call, though.
The doctor makes that call, not you.
Correct.
Correct. And since you were present prior to the time that Alexee went to the bathroom, no one from the doctor or you or other medical staff anywhere around that were there told her that she was in fact pregnant, did they?
I did not tell her she was pregnant.
You did not tell her? The doctor didn't come back and tell her?
That I know of, I don't believe so.
Well, you
Prior
were
to.
You were there the entire time.
Your Honor, Jeff, it's argumentative.
Well, I'm just refreshing his memory, Judge, to try to save us some time, but if the video shows that you were the one that was there, she was your patient, is that correct?
Correct, sir.
All right. Your Honor, at this time I have no further questions. Thank you very much.
Thank you.
Thank you, Mr. Sanchez.
Anything further from the state?
Yes, sir. Mr. Sanchez, when you say that the Mr. Officer has a bunch of questions about the defendant being pregnant, you knowing that she was pregnant, et cetera, when you testified that she adamantly denied being pregnant, what do you mean she adamantly denied?
It's one of our intake questions or triage questions we ask. I may not get the direct quote, but she said she had her period on time for the previous months. She says that she was always on time and that she just got off her period, I believe, or she had just had her period, is what she told me.
So she wasn't pregnant, she had her period on time for the previous months, just got off or barely got off.
Correct, I believe so.
Based on that, her statement and the other intake, at that point, did you have any reason to believe that she was pregnant?
No, ma'am.
Ms. Mitchell also asked you, 1251 is when this came and you had knowledge. When you get lab reports and results back, does a computer alert, a loud siren, flashing lights?
Computer? No. A lot of times the lab will call us with the positive pregnancy test.
Otherwise, you have to look for the results.
Correct. Yes.
Any objection to this witness being released from subpoena,
None.
Mr. Mitchell?
That's fine, thank you.
Sir, you've been released from subpoena. What that basically means is you're no longer going to be called as a witness. You're free to go about your day.
Thank you.
Thank you. State may call their next witness.
The state will call Lori Aragon.
Ma'am, just to confirm, you have been sworn in, correct? You've been sworn in, correct? Okay. You may proceed, ma'am.
Thank you. Please state your name for the record.
Lori Aragon,
And Ms. Aragon, where are you employed?
Artesia General Hospital.
And what capacity are you employed in the Artesia General Hospital?
What does that mean?
What's your job title?
Oh, I'm a CNA desk clerk.
Are you assigned to a specific area or department in the hospital?
In the ER.
In the ER. Ms. Aragon, I'm going to take you back to January 27th of 2023. Were you working at the Artesia General Hospital that day?
Yes, ma'am.
And where were you working?
I was sitting at my station, at the nurse's station.
Nurse's station, is that in the ER?
Yes.
I have what's been entered as State's Exhibit 1. There's a still frame on this computer. I know it's hard to see, but in this photograph, is the nurse's station or where your desk is located, is it depicted?
No.
Is in the area?
Yes, like where we're stationed at, I can see pretty much from triage 1 down to maybe room 2 of the ER.
Okay, so you can see from triage 1 to...
And trauma 1, actually, because I'm straight across from that.
All right. So, Ms. Aragon, on this day on January 27, 2023, did something happen that caused Artesia police to come out?
Yes. We had found an infant in the trash can.
Infant in the trash can. Let's start at the top. So, when did you become aware that there was an infant in the trash can?
When the housekeeper had called me over and told me that the wastebasket was heavy, and she didn't want to look, so I pulled there was a clean lining already in there. So when I pulled that out, there was paper towels and balled up trash bags. And that's when I stuck my hand in the bottom. That's when I noticed it was a baby.
We'll come back to that. So where was this trash can located?
In the patient bathroom, in the hallway.
Patient bathroom in the hallway. And is that picture depicted, or is that bathroom depicted in this still picture?
No.
It's not in that hallway?
No, it's more to the right.
More towards the right of this photo.
Yes. Oh, I'm sorry. It's straight down now that I see it.
And if you need to get up there and walk over to look at it, I'm sorry that it's not on your screen. I know it's in your order next year.
She may.
Can you describe what's near the bathroom?
There's a water fountain. And a fire extinguisher.
Thank you. You're welcome. So water fountain and the fire extinguisher, it is still, and again, for the record, it's at minute 26:21 for State's Exhibit 1. This is where the trash can with the infant is located.
Correct, yes.
Have you had any issues with someone in that bathroom prior to the discovery of that infant?
No.
Have you been asked to unlock or open that bathroom door?
That night, yes.
Okay. Tell me about that.
She had been in there for a while, and I had knocked on the door to see if she was okay, because we kept hearing the toilet flushing constantly and the paper towel dispenser going constantly. And when I knocked, the patient did answer, and she said that, because I was like, "Are you okay?" She said yes. And so I walked away, and like a few minutes more, that's when my nurse, Chris, had asked me, "Can you go and check on her again?" And so I did, and I said she just needs a little bit more time, is what she had said. So then that's when I think Chris waited a little bit, and then he went and knocked on the door after the constant flushing and the paper towel dispenser going, and that's when he called me to bring the keys to open up the bathroom, because he told her if she didn't open it, we were going to open it.
So she was told if she didn't open, so. And you keep saying she. Who do you know who that person was?
Trevizo?
Okay. Can you do you see that person in the courtroom today?
Yes.
Can you describe what she's wearing or point her out for the court, please?
What she's wearing right now?
Yes.
Oh, let me stand up.
I know that's fine.
She's wearing a blue shirt and glasses.
The record was reflecting that this identified the defendant, Alexee Trevizo.
The record will still reflect.
So it was the defendant who was in the bathroom while you were hearing the paper towel dispenser and the toilets flush. Needed a bit more time.
Yes.
I'm going to take this video. So you said you continued to hear the toilet flush. Where were you when you heard the toilet flushing?
Where the bathroom's at, they're behind me, there's a med room, and it's not very big, but you can hear the toilet flushing constantly. And that's when we noticed that she had been there for quite some time.
When you say multiple, it was excessively flushing, do you know approximately how many times or?
No, it was several times.
Would you say it was more times than anyone else who had used the bathroom or?
Yes.
Used the bathroom? You also said the paper towel dispenser, you could hear it going.
Yeah.
Can you describe that for us or explain that for us?
It was, the sound that it makes because they're automatic, like, you have to scan your hand so they make noise when they come down. We just kept hearing it going.
So it's an electronic
Yeah.
paper towel dispenser. Okay. And I'll ask the same question. Was that what you generally hear when someone else is in the bathroom, or was it more?
It was more.
Enough to cause you concern to check.
Yes.
Did you hear any other sounds or noises that were coming out of the bathroom while the defendant was in there?
No, just the flushing and the paper towel dispenser.
Okay. So when you go to the door to unlock, you said you had the keys.
Mm-hmm.
Did you have to use those keys on the door?
No, I guess she had opened the door right when I got to the water fountain.
Okay, so the defendant opened the door when you got to the water fountain, and did the defendant come out of the bathroom?
Yes.
Did you notice anything about her?
I just noticed she left like bloody footprints back from the bathroom to the room that we had her in.
The bathroom back to the room that she was in.
Yeah, she was in room 2.
Did you notice anything else about her or anything that she left behind?
When I went to open the door, like, because the nurses were there too, we noticed a lot of blood on the floor, like smeared and on the wall and on the toilet.
There was blood smeared, you said on the wall, on the toilet,
Yeah.
anywhere else?
On the floor.
I'm going to show you what's been previously entered as State Exhibit 2. Thank you. Do you, does this photograph accurately depict what you're describing, the blood that you saw that day?
Yes.
To your knowledge, was the restroom in this state before the defendant went inside?
No.
So when you saw the restroom in this state, what did you do?
I called housekeeping to come and clean the bathroom.
Did you go inside of the restroom?
Yes.
And what did you do when you were inside the restroom?
I checked the trash can and the toilet just to make sure nothing was there.
The trash can and the toilet to make sure there was nothing there. Did you see anything in the toilet?
No.
And how about the trash can?
No, just the clean lining that was on the top.
Clean lining on top. And to your knowledge, did that liner have any trash in it? Or was it just empty?
I can't recall if there was trash in that liner on the top.
Is that trash can that you're describing depicted in State Exhibit 2?
Yes.
Where, what portion of that picture is it in?
It's like right here by the wall.
The top left-hand corner,
Yeah.
is that correct?
Yes.
Was there anything?
I'm going to stop. Somebody joined us and created a little bit of an echo, so I'm going to see where that's at. Put yourself on mute, Ms. Gonzalez, or maybe move your computer a little bit away from the... You may proceed.
Okay, so, Ms. Aragon, so you notice, other than the items that are shown in State Exhibit 2, was there any other trash cans or furniture that is located in that bathroom?
There's a cabinet, and it's by the bathroom door when you come in on the right-hand side.
Cabinet by the bathroom door. And did you also inspect that cabinet when you were looking into the toilet and
Yes, ma'am.
Was there anything that you located in or on around that?
No.
All right, so once you inspected that, you called for housekeeping to come? Did housekeeping come?
Yeah, she came, I think maybe 10 or 15 minutes later because she was cleaning something else at another part of the hospital.
In between the time that the defendant left the bathroom and housekeeping came, did anyone else use that bathroom?
No, ma'am.
What was the housekeeper's name, do you recall?
Leela?
So, Leela came, did she begin to clean the...
Yes.
Okay. And, did you have any other interactions or anything else to do with that patient after?
Just when she had called me to notify me that the wastebasket was heavy. And then that's when I had told, because of what we found, that's when I told her to stop cleaning.
So when the housekeeper showed you, or informed you and showed you that the wastebasket was heavy, you previously described it to have a liner, I think you said rolled up paper towels and trash bags.
Underneath it.
Did you remove those items from the trash?
Yes, ma'am. When I picked up the wastebasket and felt that it was heavy, I removed the top liner. And on top of the underneath the liner, there was balled up paper towels. And then underneath those were trash bags. And then when I removed those items, that's when I noticed there was a baby at the bottom.
So what you're describing to me are different layers of what's located, or what was found in this trash bag. So you said clean liner, balled up paper towels, and trash bags.
Yes.
And then on the bottom was the baby.
Yes.
Was the baby located in anything?
It was inside of another trash bag.
It's inside of another trash bag. Can you describe how this baby was inside of the trash bag?
It was like they had twisted it and tucked the twisted part of the top of the bag underneath the baby.
The top, where the opening is that what you mean?
Yeah.
The opening part is twisted, and you said that is tucked underneath.
Yes, because when I went to stick my hands under, the bag loosened, and that's when it suctioned to his face, and that's when I knew that it was a baby.
So you picked up the bag with the baby, and you said it loosened and it suctioned to his face. The
Yes.
bag suctioned to his face.
Yes.
So once you did that, and you discovered that this was in fact a baby, did you put him back into the wastebasket, or did you?
Yes, I put him back down, and I called for my charge nurse, which was HT, and then when he came, I told him I found the baby, and he's the one that took the wastebasket, and I was notified to call 911.
I'm going to show you what I've marked as States Exhibits 3 and 4 for purposes of identification. Yeah.
You may.
Ms. Darnell, would you like to go through these photos?
Yes.
What are these photographs of?
What was in the wastebasket?
Okay. So we'll start with photograph 3. You previously described balled up trash bags, paper towels. Are those depicted in this?
I can't really tell.
Okay. You can't really tell. Okay. Is there also a roll of trash bags in that photo?
Yes.
Was that present when you found this baby?
Yes.
It was. Okay. All right, and we'll go to number 4. Exhibit 4, I'm sorry. And the same question, does that accurately reflect what you saw or how it was when you handled that trash can that day?
Yeah. I think some stuff were moved around, but yeah, that's how it looked.
Okay. Your Honor, I'd like to move states 3 and 4 into evidence.
Any objection?
The same one I've been making, but otherwise none.
Objection noted. States Exhibits 3 and 4 are admitted into evidence.
Mr. Aragon, the items that are in these photographs, was all of that on top of this baby?
Yes.
City Hall for charges of is that a name in the game?
Yeah, that's what we call them.
Okay. Do you know what his full name is?
Honestly, no. I've always called him HT.
Okay.
I want to say maybe it's Hillard.
I'm going to show you, and I'm going to present additional frames of State's Exhibit 1, Your Honor, if I may. At 5425.
Mr. Fitzgerald, do you mind leaning back just a little bit? Thank you.
5423. Is this portion of the video that I just played, does that accurately depict what you just described for us?
Yes.
When you located this baby in the bag, was it making any sounds, movements, anything like that?
No. Just the face and that he had black hair.
At any point after your discovery and either between HT and Dr. taking the baby from the trash can, did you go back into the bathroom or did anyone else go back in the bathroom?
No. I did go back into the trauma 2. That's where the baby was.
You know if it was a boy or a girl?
It was a boy.
To your knowledge, was he still alive?
I didn't know if he was alive or like if he was born alive or dead at that time. No.
So you were asked to call 911, did you call 911?
Yes.
Did law enforcement come?
Yes.
Did you have any other involvement with this baby boy or the defendant?
The only time I saw her was when we were transferring her to another hospital for higher level care, and I just had to go and have her sign the paperwork to have her released from our hospital.
You had to have the defendant sign.
Yeah, the teleforms. It's the teleforms, and then the paperwork for the flight crew that was transferring her.
That's all the questions I have. Thank you. I'll pass it over.
Mr. Mitchell, you may proceed.
Thank you. Ms. Aragon, did you observe the patient, Alexee, when she went to the restroom?
I saw her pass by. Yes.
Did you make a comment at that time that when you have to go, you have to go?
Yes.
Did you notice that she had one hand on her crotch and one hand on her butt? I mean, those were your words?
Yes. She ran to the bathroom like she really had to go.
Yeah. Now, do you assist nurses in getting patients undressed and set up for examinations?
I do once in a while. Yes.
Okay. Did a nurse, were you the nurse that helped her get unhooked from the IVs to go to the restroom?
No.
Was that another nurse?
That was another nurse.
Do you know who that nurse was?
I don't recall.
All right. But at the time that that nurse went in to do that, and she was going to the bathroom, had you already received any orders to do a pap smear?
No.
Okay, so you didn't know anything about a pap smear.
Mm-mm.
Where was the doctor at that time?
I think she was sitting at her station.
Where's her station?
Like down to my left.
How far?
Maybe two chairs away from me.
2 chairs away from you?
Yeah, because I sit in the corner, and then there's a chair next to me, and then there's another chair, because there's 3 computers at our nurse's station, and then there'll be like a little gap for like a doorway to come and go, and then the doctor's station is in that left-hand corner.
So, you guys are seated at basically what we would call the nurse's station in the ER, is that correct?
Yes.
And so, did you make the comment about when you have to go to the doctor?
No.
Did you make it, but in her area so she could overhear?
No, I said it to Erica, I was like, dang, this poor girl, I guess she really has to go.
Okay. Well, by the way, where was at that time, where was Nurse Chris Sanchez?
I think he was in the med room getting some medications or IV supplies for her.
But could the doctor see that patient was going to the restroom? So where she was seated?
Yes, you can see it.
And obviously, if a nurse went in to unhook the IV, did that nurse have to get permission from the doctor to do that?
No.
The nurse can do that without the doctor's permission, as far as you know.
Yes.
But do you have access to the same computer system with instructions from the lab or information from the various labs that come into the nurse's station and to the doctor? Do you have access to that?
Yes, I can see the same readings as they can.
I'm sorry, say it again.
I can see the lab results the same as the nurse and doctors can.
Okay. Were you paying any attention to the lab results that night?
No.
All right. That's the next question. Am I correct that the doctor, once she came down after what was found in the trash can, that she took the trash can into another room there and dumped it?
I don't know. I wasn't there when they took the trash can. At that time, I believe I was already on the phone with 911.
All right, fair enough. Thank you very much.
Anything further for this witness from the state?
No, Your Honor.
May this witness be released from subpoena?
She may, yes.
Any objection?
Yeah, ma'am, you've been released from subpoena. What that basically means is you're not going to be called back to these proceedings. You are free to leave and go about your day. Thank you.
Thank you.
State may call their next witness. And just to clarify, Ms. Gonzalez, how many witnesses do you have in total?
Lab? 6, I believe.
6, okay.
She was there. She was there for this. We did. This is what it is. It's insane.
Good afternoon, ma'am. Just for the record, to confirm, since I swore in everybody all at once, I'd like to confirm you were sworn in, correct?
Yes.
Okay, thank you. You may grab a seat.
Ma'am, please state your name for the record.
Leela Lewis,
And Ms. Lewis, where are you employed?
Artesia General Hospital.
And what's your job title at Artesia General Hospital?
I work with the EVS department, which is housekeeping.
Mrs. Lewis, were you working on January 27th of 2023?
Yes, I was.
And on that date, did something happen that caused law enforcement to come out to the ER at Artesia General Hospital?
Yes, there was.
Can you tell us what happened?
I happened to be cleaning the bathroom, the patient's bathroom in the ER, and there was a baby in the trash can.
So you said the patient after in the ER, and you said you were cleaning it. Was this just a general rotation clean, or was there something?
No, I was called to go in there and to clean it up
By whom did you call?
by Lori that works. She's the ER tech.
Lori Aragon?
Yes.
So Lori Aragon called you to go clean up, and when you got there, what did you notice about the bathroom in the area?
There was blood everywhere.
What do you mean by everywhere?
There was blood on the walls. There was blood around the toilet. There was blood on the floor.
Was this inside the bathroom or in the hall outside?
Inside the bathroom and outside the bathroom, there were some footprints.
The footprints, what made them notice the footprints?
Because there were blood.
Were you there to see how the bathroom came to be in the scene?
Excuse me?
Were you there to see how all of this blood got into the bathroom and into the hall outside the bathroom?
I was there afterwards.
So was Lori
Yes, ma'am.
So, when you began cleaning the bathroom in the hall, how did you start?
I started by mopping the floor first because if not, I was going to track the blood all over the place. And then I started wiping the walls and the toilet. And the last thing that I did was throw the trash. I was going to get the bag so I could throw the trash, and that's when I noticed that there was a baby on the bottom of the garbage bag.
Trash was the last thing that you were doing?
Yes, ma'am.
If you want to friendly pass her State's Exhibit 2.
That's the
Yes. And if you can just take it from the judge. Does this State's Exhibit 2 depict what you just described for us, the blood on the floor and toilet in the bathroom in New York?
Yes.
Is that how it looked when you got there?
It seemed to be worse than that, but yes.
Was everything in the same place, the trash can?
Yes.
The toilet seat, everything like that?
Yes, ma'am.
So, say you walked so that you would track the blood anywhere else, clean the well, clean the toilet, and then you said in the trash can was where the baby was. Is it that trash can that's
Yes.
depicted in that photo?
Yes.
And before you handled that trash can, was there anything odd that you could tell about it? Did it look different or have something in it that you could just visually see?
The weight of the trash can for the amount of trash that was in it.
So just the weight, was it anything else that alerted you or caused you concern?
No, because when I picked up the trash bag to throw it away, there was a trash bag under that.
The trash bag to throw it away, you said there's another trash bag underneath that. What state was that second trash bag in?
It was wrapped around the baby.
Recall how it was wrapped around the baby?
I just remember it being wrapped like that with the opening part under it.
Kind of pulling your hands around. So let me just kind of go so that we understand the opening part of the bag. Were you able to see that part?
No, it was tucked under.
It was tucked underneath it.
Yes.
Do you remember if it was just folded, if there was something on it holding it closed?
No, there was nothing on it holding it closed.
Just folded it.
Yes.
So when you made this discovery, what did you do?
I called for HT, which is the nurse that night, and Lori.
Did they come?
Yes, they came right away.
And what happened next?
Then after that, they took the trash to the baby, where the baby was, into the trauma room. And then after that, I don't know what happened. I went on to the front of the ER.
That was your last interaction?
Yes.
With the baby or that situation?
Yes, ma'am.
Miss Lewis, in the trash cans that are at Arthur General Hospital, specifically this one, do you leave a roll of used or new trash can liners?
Yes, ma'am.
Is that customary for the hospital?
They do that all the time, yes.
And was that the case for this trash can in this bathroom, that it had a fresh roll of liners?
Yes, there was extra trash bags.
Ms. Lewis, you said before that you took the trash bag out and then you saw the baby. Were you able to see the baby before you took that first trash bag out of the trash can?
Yes, I did.
so in that picture in State's Exhibit 2, you can see over the trash can that there's the line over the trash bag. That's how it was when you saw it.
Mm-hmm.
Was that the trash bag that the baby was in, or was it?
No, there was another one. He was in a different one.
Underneath that.
Yes, ma'am.
Mr. Mitchell,
I have no questions of this witness, but thank you.
may this witness be released from subpoena, ma'am?
She may.
Ma'am, you've been released from subpoena. What that basically means is you're no longer going to be called back as a witness, so you don't have to wait here at the courthouse for any future testimony. You are free to go about your day. Thank you,
Okay.
ma'am.
Okay, thank you.
You can hand me that exhibit to you. Thank you.
The state may call their next witness.
Your Honor, the State will call Hillard Holliday. Or Halliday, I'm not sure.
Sir, I swore in several people at once. I just want to confirm you have been sworn in, correct? Yes, sir. Okay, thank you. You may grab a seat, and if permissible, if you could remove your hat for the proceedings. Thank you.
You may.
Sir, please state your name for the record.
My name is Hilliard Halliday.
Mr. Halliday, do you go by Hilliard, or do you go by something else?
I go by HT.
Mr. Halliday, where are you employed currently?
I am employed at Artesia General Hospital.
What's your job title?
I do house supervisor, charge nurse, and regular RN duties in the ER.
You're an RN.
Yes, ma'am.
Mr. Halliday, I'm going to take you back to January 27th of 2023. Do you recall what hat you were wearing that day?
I believe I had on a red skull cap. Is that what you asked?
Sorry, I
Sorry.
didn't actually have that on, but I mean, were you the charge nurse?
Oh, yes, ma'am. Yes, I was the charge nurse of the night shift. Yes, ma'am. In the ER.
Charge nurse of the night shift in the ER. And what does that entail, being a charge nurse?
The charge nurse is responsible for any, well, first you are on the code team, you're on the rapid response team, you're the team leader for any stroke, cardiac trauma. You also deal with any problems that your nurses arrive with your patients or family members, or any abnormalities with any of the ancillary units that you have. So you deal with those.
No, Mr. Halliday, on this date, did you have interactions with a patient named Alexee Trevizo?
Yes, ma'am.
Well, just before we get going, do you see Alexee Trevizo in the courtroom today? And is she wearing a
She's got glasses and she's a black shirt. She's sitting right there.
Your Honor, the record reflects the witness has identified the defendant, Alexee Trevizo.
The record will still reflect.
Mr. Halliday, what type of interaction did you have with the defendant?
My interaction was some things that happened, and the primary nurse that was taking care of her had came and asked or told me a few things, so I had to interact with her and ask her a few questions about what went on when she was in the bathroom.
So things that have happened in the ER. What happened that you had to either intervene or give your attention to?
Well, the first interaction was with Chris, who was our primary nurse. He came to me and said,
Was that first? So let me bring that. So your first interaction was with Chris, and he was providing you information about his interaction.
yes, ma'am. Yes, ma'am.
Was it at this point that you then interacted with the defendant, or did you just?
Not at that time, no.
Then how about the next interaction?
I was, yes, I did interact. I had to go in the room and talk to her, yes.
When into defendant's room to talk with her, was that about what you had discussed with Chris, or was that about what had occurred in the bathroom?
What had occurred in the bathroom?
So before we go on to what had occurred in the bathroom, did what the defendant said occurred in the bathroom? Can you tell us what was going on with her in the bathroom that caused concern or issues?
I was told that they could not get her out of the bathroom.
Do you recall what bathroom that was?
She was in the patient's bathroom in the ER. I personally did not know.
So you said that the next interaction was when you went in to speak with the defendant about what happened in the bathroom. Did the defendant tell you what was going on in there?
She didn't actually tell me what was going on in there. She just told me, I guess, what she felt happened.
What did she say?
She said that her words were that the baby just came out of me. I was scared. I didn't know what to do.
The baby just came out, she was scared and didn't know what to do.
Yeah.
Did she say anything else about the baby?
No.
Was this information, this statement, spontaneous, or did you ask her a question?
I asked her a direct question.
What question did you ask her?
I asked her, "Can you tell me about the baby in the trash can?"
Can you tell me about the baby in the trash can? And her response was, it just came out of me and I didn't know what to do.
Yes, ma'am.
Was that the first, well, I shouldn't say the first, let me just withdraw that question. Did you question further anything about the baby or her involvement with this baby?
Not really. At that time, Dr. Vasquez was in the room and she kind of took the lead.
Was there anyone else in the room other than yourself, Dr. Vasquez, and the patient?
I believe her mother was in the room at that time.
Was law enforcement present?
Yes, ma'am.
And at this point, Mr. Holly, I'm going to presume that this baby had already been found in the bathroom.
Yes.
Had he already been treated or attempted to be treated?
Yes.
Can you tell us about your involvement with that?
I was called to the restroom by 2 other employees. When I went in there, the baby was in the trash can. I picked up the trash can, went over to the trauma, took him straight across the hall to the trauma room, got him out of the trash, and started assessing vitals.
Do you recall how this baby was situated in the trash can?
The baby was in a liner with trash in it, and then I had to remove another liner on the top of that.
So the baby was in his own specific liner that contained trash?
Yes, ma'am.
And then on top of that
Was another liner.
was another?
Yes, ma'am.
Do you recall anything about the bag, the the baby was located in, other than it had trash in it, if it was open, if it was closed?
It was tore partially open.
What part of it was torn?
Just the part kind of over the face. No, I did not.
Do you know that?
I didn't see it, but I believe Lori.
Objection to the speculation then.
Ms. Gonzalez, your response?
Your record would lay a little bit of foundation.
Sustained.
Did you, before I ask you that question, did you speak with your staff or debrief about the situation?
Yes.
And based on that conversation, did you come to a conclusion about who you believed to have torn that bag?
Yes.
Okay.
Lori.
Judge, it doesn't change the hearsay. I mean, the fact that we're already violating the doctor-patient privilege here doesn't give them the right to use hearsay.
Your Honor, I'm not asking you to tell me what Lori said.
I must stop you there. As the parties are aware, the rules of evidence do apply to a preliminary examination. Hearsay does apply. However, the rule of confrontation under State v. Lopez does not. I believe that this question is permissible as it ultimately comes down to the confrontation, rights to confrontation as opposed to hearsay. So I'm going to overrule the objection and allow the question. Yes, you may answer, although you've already answered, but just let's clear up the record. Can you have him answer the question?
Yes. So you testified that it was torn partially over the face, and you believed, based on the information, that someone had done that. Who do you believe?
Lori.
Lori Aragon?
Yes, ma'am.
So when you started assessing the vitals of this baby, what did you notice?
There was 0 respirations and there was 0 heartbeat. And the temperature, I checked the temperature, which was below normal.
Do you recall what the temperature of this baby?
I don't recall the exact number, no, ma'am. Yes, ma'am.
Were there any attempts at resuscitation on this baby?
At that time, no.
Who was in the trauma room while you were making these assessments
I don't recall. I may have been by myself. Maybe, I don't remember, actually.
Did Dr. Vasquez ultimately come in?
Yes.
Did Dr. Vasquez perform any type of resuscitation?
I don't believe there was resuscitation, but she performed an assessment as well.
So no resuscitation, but an assessment of...
Yes, ma'am, of the vitals. Yes, ma'am.
Was this baby at this point deceased?
Yes, ma'am.
Is there anything that you noticed about the baby injuries, anything that is out of the ordinary other than it being in the trash bag?
That it had an unusually long umbilicus attached to it.
Unusually long umbilicus. Was this, or were you able to tell if this umbilicus was attached to, or was it intact, or had it been severed?
It looked to me that it had been severed. There was no placenta.
It had been severed and there was no placenta. To your knowledge, Mr. Howley, was the placenta ever located in the bathroom, in the patient room?
No.
With this baby?
No.
Mr. Mitchell.
Thank you.
HT, as I understand it, as the charge nurse that night, you had some discussions with and review of charge or whatever for this particular patient. Is that correct?
Yes, sir.
And when the patient came in, when Alexee came in, did you do the triage?
No, sir.
Who did the triage, if you recall?
I believe it was Chris.
Chris did?
Oh.
Chris Sanchez?
Yes, sir.
All right, good. And am I correct that she was complaining of back pain and abdominal pain?
Back pain, yes, sir.
All right. And you were going to treat her with regular medications for back pain until the doctor examined her.
That's correct.
And somebody had already taken a pulse, heart rate, and taken some vitals. Is that correct?
Yes, sir.
The doctor saw that on the chart and was concerned about the heart rate, wasn't she?
Yes, sir.
Among other things.
Yes, sir.
So the doctor moved her, asked that she be moved to another room.
Yes, sir.
And then you took blood, and I don't know if you got a UA or not, but in looking at your medical records, I didn't see one, but I saw the blood.
I personally didn't do that, but yes, that was done.
Okay. Now, were you present when the patient went to the restroom?
I was not in the room or in the bathroom with her, no, sir. I was at the nurse's station. Yes, sir.
Did you actually see her go?
I did not actually see her go. I believe I was triaging another patient.
All right, fair enough. Did you know at that time that the lab had reported back at 12:50 or 00:50 hours that they had a positive test for her being pregnant?
I was made aware that she had a positive pregnancy, yes, sir.
Okay. You didn't tell her that she was pregnant, did you?
I did not, no, sir.
Is that typically left up to the doctor on call?
Usually the doctor or the primary nurse.
All right. And the primary nurse was Chris Sanchez?
Yes, sir.
Now, you were aware, as an experienced nurse, from all the information I've read, you have a great deal of experience. Is that fair?
Yes, sir.
And you're aware as an experienced nurse that once you have a patient that's female and of childbearing age complaining of back pain, for example, that it's very important to determine if that patient is pregnant or not.
Yes, sir.
And another thing that's very important is that that patient indicates, if you already know that she's pregnant and that patient indicates to you she has to go to the restroom, it's probably advisable to do a check and see what the situation is. Is that right?
Sometimes it just depends on the situation, though.
Sure. And in this instance, it would, and let me just ask you this as a charge nurse that night. The ER wasn't busy, was it?
Not tremendously so, no.
I mean, it's not like we had something, a bad accident in the oil fields, or we had a bad car wreck, or a plane crash, or something like that.
No, sir.
I mean, this was a Thursday night, Friday morning.
Yes, sir.
When you talk about that baby had an unusually long umbilicus, That's compared to the other babies you've helped deliver, and you've helped deliver several.
Yes, sir.
And does that concern you for potential entrapment?
My concern was for the placenta and it being retained by the mother. That was what my concern was with that.
Well, and thank you for that. I appreciate that concern, because that means if that placenta is still retained for the mother, that could be
It's life-threatening.
life-threatening.
Yes, sir.
And I thank you for the knowledge and the concern.
Yes, sir.
You didn't locate the placenta, did you?
No, sir.
But you helicoptered her out to Loveless and Roswell.
Because yes, sir. That's
Because of that.
yes, sir.
And when you observed the baby and determined that the baby was deceased, was dead, you didn't see that there was any resuscitation that you could do that would revive this baby, did you?
No, sir.
Thank you, H.T.
Yes, sir.
That's the witness.
May this witness be released, or do you have any further questions?
He may be released, Your Honor.
Any objection, Mr. Mitchell?
No objection.
Okay, sir. You are released from subpoena. What that basically means is you're not going to be called back as a witness. You are free to leave the courthouse and go about your day. Thank you, sir.
Yes, sir.
Next witness will be Dr. Vasquez. I'm texting her right now.
Okay. Do we have any other witnesses present here at the courthouse?
Yes, Your Honor.
Okay.
Officer Williams.
Okay.
That I can.
No, I'm not going to tell you. I was just I'm not going to tell you who to put on in what order or anything of that nature. I just wanted to confirm. So I'm going to go ahead and since we're recording this, I do have a speaker next to the computer. I'm going to move the microphone next to the speaker so that we can pick up the recording. Isabel, if we have any problems hearing that, okay. As long as we can hear that witness on the computer, if we're having problems, just let me know and we'll do whatever we need to do to make sure the record is clear. Okay.
And, Your Honor, when we examine that witness, do we have to be up there to examine the witness?
We'll see how we can go about it. I have no objection if you want to come up here to do the examination so that they can hear. I know there may be some problems hearing. If you want to try it from there to start off with, that's fine with the court. But again, whatever is most convenient for all the parties, and so that everybody can hear each other.
Your Honor, I will have exhibits for Dr. Vasquez. I think that I can log in and display them via the Google Meet.
That's fine. Ms. Gonzalez, Mr. Mitchell, please approach. Just to let the parties know, we have, this is a public forum, so I have people on the Google Meet, including news media, who are listening to this hearing. If you display that, an individual may have the capability of taking screenshots. So how you want to proceed is up to you, but that's, I'm not going to say you can't display it, but you do have to be aware of that possibility.
Never had to encounter that issue before because there's no cameras in the courtroom usually. Your Honor, I don't see another way that we can get them to Dr. Vasquez unless we email them, but then I can't see what she's looking at talking about. Maybe you can do a reminder that there's no...
I will let the parties know. I mean, with that being said, that does have sometimes the effect of don't think about a pink elephant statement. So, I mean, I'll leave it. They're not going to know what the exhibit is until you show it. However you want to go about it, whatever it thinks the best way to go about this, but just be aware, like I said, there's individuals who may attempt to take a screenshot of that, and if they are given warning of it, they may be prompt to do so. If you don't give them warning, they may not be unaware until a certain point. However you want the court to proceed on that.
I don't know what the back, because I understand what they're saying, but I don't know what the better option is.
It's kind of the Kobayashi.
Yeah.
Sort of.
I would think at least if we can remind them that it's not permitted, at least we've done our, the diligence that we can.
That's fine.
Please.
Okay. Doctor, before we start, I just want to confirm, and I know that I swore you in, but I've been asking every witness before we started if they have been sworn in. Can I confirm that you were sworn?
Yes, sir. I was sworn in.
Okay, thank you. And I'm going to let the parties know who are currently on the line. This witness is going to testify remotely through Google Meet. There are going to be some exhibits displayed to her through Google Meet. I do remind the parties you are not permitted to take screenshots of these exhibits or to copy them and to share them or to make any sort of copy of these exhibits as they're shown to the doctor. Ms. Gonzalez, you may proceed. Doctor, we're going to try and conduct this examination with the attorney standing at the podium. The microphone there goes to our recording system, but it does not amplify her voice here in the courtroom. If you are having trouble hearing her, we'll work around that and have her come up to the podium. So let us know if you're having trouble hearing her. She can come up to the bench, but we're going to start with her at the podium right now.
Thank you, Judge.
Can you please state your name for the record?
Heather Marshall Vasquez.
Okay. And where are you employed?
My full-time employment is with Holy Cross Medical Center in Taos, New Mexico, but I also do, I'm an independent contractor at Artesia General Hospital and work 2 to 4 shifts per month there.
You said 2 to 4 shifts per month at the Artesia General Hospital?
In Artesia.
What
Correct.
department do you work those shifts?
Emergency department.
Now, Dr. Vasquez, were you working a shift in the emergency room on January 27th of 2023?
I'm sorry, I couldn't hear that.
Were you working a shift on January 27th of 2023?
That's correct. Yes, I was.
Okay. Do you recall the hours of that shift?
7 p.m. to 7 a.m.
On that date, did you have contact with Alexee Trevizo?
She was a patient, yes.
Okay. And what was Ms. Trevizo in the emergency room for?
Could you repeat that?
What was Ms. Trevizo in the emergency room for?
She presented with a complaint of back pain.
Was she admitted to the emergency room?
I didn't quite catch it. Was she what to the emergency room?
Admitted?
She was evaluated in the emergency department. Correct. She was a patient in the emergency department.
You might approach it.
You may.
Probably will approach them with that. All right. Can you hear me better from here, Dr. Vasquez?
Yes. Thank you so much. I'm so sorry.
No, that's okay. It's not your fault. So she was evaluated in the ER, and was she, I said admitted, or was she taken back and placed in a room in the emergency room?
She was, so if I may just clarify, the term admitting indicates a patient was admitted to a hospital.
Okay.
An emergency department is not considered, a patient checks into the emergency department, which she did.
Okay.
She was placed in a room in the emergency department for further evaluation.
Okay, I understand. Thank you for clarifying that for us.
Yes.
So you said her chief complaint was for pain. Was she treated for that pain?
was she was evaluated, and I felt that she needed additional evaluation other than just a physical examination. So laboratory studies were ordered initially, as I believe, I don't have the record in front of me, so I cannot tell you at what time a CT scan was ordered, but I believe it was at the time of the initial evaluation.
Okay. The tests were ordered. While you were either conducting these, waiting for results, or while she was just in your emergency room, did something happen with Ms. Trevizo that caused concern or an issue?
Well, she was complaining of very severe pain, and she would not allow me to physically to examine her completely. So she was walking around the evaluation room, and I couldn't complete a abdominal examination. I was able to look at her back, but I couldn't complete the evaluation. And that seemed it was a little bit inconsistent with what you would normally expect, like a muscle strain. And so I felt that further investigation was warranted to make sure she didn't have a kidney stone or additional things going on. And we always order a pregnancy test on a patient who presents, if it's a woman within childbearing age, they get a pregnancy test no matter what. And so I ordered a pregnancy test as part of the evaluation, knowing I thought I might have to do a CAT scan. And we generally don't do CAT scans on pregnant women because of the risk of radiation.
Okay.
So these tests were ordered, and then as I had finished evaluating her, she abruptly left the evaluation room to go to the bathroom.
So I just want to go back. So you said that you were having difficulty evaluating her, performing an examination on her. You said she was walking around the patient room?
That's correct.
Is that uncommon for someone who comes to the emergency room?
It's difficult to answer that. Each case is different.
Okay.
Some patients are so uncomfortable that you cannot evaluate them without administering medicine. So we will frequently administer medicine to try to make a patient more relaxed or more calm so we can so either we can get a better history or get a better examination. And that was my hope in this case.
Okay. So
initially.
You provided some medication in the hopes that you would be able to evaluate her situation.
And she was very obviously uncomfortable. And again, as I mentioned before, my initial concern was kidney stone or something of that nature, because she was then complaining of back pain.
Okay. So then you said that the defendant, or excuse me, Ms. Trevizo abruptly left the examination room. And
That's correct.
Where did she go?
She said she was going to the bathroom.
Okay. Did she say anything else about why she was exiting the exam room?
She did not, but at that time I asked the patient and her mother who had brought her if there was any chance she could be pregnant, and I cannot remember if the patient responded, but her mother said that categorically it was impossible, that she had been buying her pads every month, and she was certain she'd had periods every month. There was no way she could be pregnant.
Okay, and so with this information that you received, did you see any issue in Ms. Trevizo going to the bathroom?
No, I mean, the emergency department, patients have their free will. They can, I mean, if she wanted to go to the bathroom, that's within her rights.
Sure. Okay, so Ms. Trevizo goes to the bathroom, and does there become an issue with her in the bathroom?
So after when she went to the bathroom, then I went back to my workstation and began entering orders as well as initiating my documentation. And I was not aware that she hadn't exited the bathroom until much a period later. It was after we received a positive pregnancy test, and we were waiting to get a further quantification of what we call basically it's a quantification of the pregnancy hormone level, because that was really critically important to me from a medical standpoint, because as soon as I realized that her pregnancy test was positive, another diagnostic possibility that's potentially life-threatening, specifically a ruptured ectopic pregnancy, becomes concerning. And so we really need that hormone level, like the actual numerical number, to evaluate how risky it is that a patient could potentially have a ruptured ectopic pregnancy, which is life-threatening. And so it was, I can't tell you the amount of time that it elapsed because I don't have access to the medical record right now. But at some point, as I was waiting for the final hormone level to become resulted, I asked where the patient was, and I was informed that she was still in the bathroom. And at that point, myself and the nurse went to the bathroom, and I said, we need to get her out of there now. Because I was concerned that there could be a life-threatening emergency, and we needed to get her. We needed to call in an ultrasound tech because we don't have 24-hour ultrasound at the hospital. And so there were just things that needed to happen, and at that point, we couldn't get her to come out.
What do you mean by you couldn't get her to come out?
We knocked on the door and said, you need to come out. There was probably about a 15-minute period from when I said we need to get her out of the bathroom to when we got access to the bathroom. I heard the toilet flush several times, and so I kept thinking, okay, she's flushed the toilet, she's going to come out, and then she didn't. And when I heard the toilet flush a second time, I instructed staff to get keys to the bathroom and to forcibly get into the bathroom.
Okay. Did you have to forcibly get into the bathroom, or did Ms. Trevizo come out?
I'm sorry, I cannot recall. I don't know the answer to that.
Okay. Were you present at the bathroom when Ms. Trevizo came out?
I was.
Okay. And did you notice anything about her that was different from when you had seen her in the patient room?
There was a significant amount of blood in the bathroom. It was everywhere. It was on the floor and the toilet. And so, if you recall, I said we have to call in an ultrasound tech. Mm-hmm. We had an ultrasound machine in the department, but it didn't have the right kind of probe. But when I saw the amount of blood, I just was concerned that there was an emergency of some kind happening. And so I wanted to, even though I didn't have the right probe, I thought, let me just look and see if I can see if she has this ruptured ectopic pregnancy. And so I myself and a nurse walked her back to the room, and I got the ultrasound. And again, I didn't have the right piece of equipment. I had to call in the tech for that. But I couldn't really see much with the ultrasound, but she was bleeding a fair bit. And so at that point, we proceeded to perform a pelvic examination so I could figure out either how much she was bleeding, or if she was having a miscarriage was another possibility. And so, yeah, I'm sorry, I'll stop there.
Okay. So you weren't sure what was causing all this bleeding, but further studies needed to be done. Correct?
That's correct.
Okay. So, do you know, let me withdraw that. So while you were evaluating and or treating Ms. Trevizo, did you get pulled from her to another issue?
Did I what?
Did you get pulled from tending to her to tend to another issue?
I do not recall. Well, let me rephrase. I performed the ultrasound. I left the room to get the room set up for a pelvic exam. The nurses had to get some equipment. We went back in and I performed the pelvic examination, and there was so much bleeding. It took me a very long time. The cervix was completely open, and so at that point I began thinking, well, she must be having a miscarriage. And there was a lot of bleeding, and so sometimes in order to help stabilize a patient if they're having an active miscarriage, we have to evacuate all of the blood and other products from the uterus or from the cervix. And so it took me about 15 minutes, and there was just really significant amounts of clot. And so just as I had finished the examination, the charge nurse did come into the room and said, "Dr. Vasquez, I need you outside immediately."
Okay.
And so the nurse stayed in the room in order to help get the patient cleaned up. And then I walked out into the hallway, and charge nurse HT informed me that a dead baby had been found in the trash can of the bathroom.
Okay. So when you got this information from HT, what did you do from there?
Well, my first obligation, or my first choice was I wanted to see if the baby was alive and needed resuscitation. And so I said, where is this baby? And they brought the trash can to me. And I grabbed it and I just ran with it into a resuscitation room, and I turned it over onto the bed, and the baby came out and was on the gurney.
Okay. Can you describe how the baby was situated in the trash can when you saw it?
I never looked in the trash can. My priority was in assessing for resuscitation.
Okay.
And so I didn't look in. I just turned it over and put it on the resuscitation gurney so that I could assess whether or not the baby was alive, if there were signs of life, if the baby needed resuscitation.
Okay. All right. And so when you did turn the trash can over onto the bed, you said the baby came out. What was with him when he came out?
I don't recall. All I can tell you is that the baby was cold and pulseless and dead.
Cold, pulseless, and dead. Did you make any attempts to resuscitate him?
I did not. I assessed for breathing, which there was none, pulse, which there was none, and the baby was cold, which suggested to me that he had been in the trash can without air for a longer period than what would make for the remotest chance of a successful resuscitation.
So based on your assessment, you determined that he was deceased?
That is correct.
Dr. Vasquez, I'm going to show you what I'm marking as States Exhibits 5 through 18 for purposes of identification. I don't know if I may publish those
You may.
in the Google Meet. I'll show it to you first.
Oh, no, it's okay. Okay. Let's see.
Can you see those, Dr. Vasquez?
The bottom half is cut off.
And I'm going to have to scroll down because some of them are scanned long ways instead of widthwise. So I'll go through slowly, one at a time. If I'm going too fast, please just let me know, okay? So this is State's Exhibit 5.
Okay, I can see it.
This is State's Exhibit 6. This is State's Exhibit 7. This one is number 8. It's number 9. This is number 10. This is number 11.
Circulation change.
This is number 11. This one's number 12. It's 13. This one's 14. $15. 16. 17. And then this one's 18. We're able to see all those photographs, Dr. Vasquez?
Yes, ma'am.
Do you recognize what's depicted in these photographs?
Yes.
Do they accurately reflect the baby that you treated on January 27th of 2013?
Yes.
Okay. Your Honor, I'd like to move State's Exhibits 5 through 18 into evidence.
Mitchell.
I've noted everything, Your Honor.
State's
Thank you.
Exhibits 5 through 18 are admitted to evidence.
They're exactly the same. They're just hard copy. No, I'm going to put a photo up for us to discuss, Dr. Vasquez. And it's going to be State's Exhibit. This one. State's Exhibit 6. Can you see that one?
Yes.
So is this, you previously testified that you had just dumped out what was inside of the trash can. Was this how you assessed the baby when you made, checked his vitals, determined he was cold, etc.?
Yes, we made no, very little alteration to the position of the baby on the bed.
So the bag that we see on the left side, is that the bag that this baby was contained in?
All I can tell you is what we see right there. I don't know.
Okay.
I didn't, it came out of the trash can with the baby.
Okay. So that was in with the baby?
That's correct. And I don't know what manipulation happened prior to with bags or whatnot before I grabbed the trash can. I just don't know.
Okay, so all you know is what it looked like when you grabbed it?
That's correct. I took the can and physically turned it over to assess the contents, and then we didn't touch anything.
Okay. All right. Dr. Vassis, were you able to tell how this baby had died?
No.
So once you made the determination that he was deceased, what did you do next?
Well, there were two nursing nurses with me at the time of the assessment. I instructed them to call the police and that we would notify the patient of what had happened with police present. Once I made that determination, I then proceeded to understand that the bleeding from the patient's cervix was from a delivery.
Okay.
And I did not know where the placenta was or if she had retained products of conception. And so my attention turned to stabilizing the patient and making sure she didn't die from a postpartum complication. And so at that point, I contacted the obstetric unit at Loveless in Roswell, spoke with the on-call physician, whose name I cannot recall. I explained the situation and said we need to emergently transfer this patient so that she can be stabilized because we don't have obstetrics or gynecology at Artesia General.
So she was transferred to another hospital?
Yes.
Okay.
Yes, so my first step was stabilization of the patient. Once that was finalized.
Please hold on for the question.
If you'll hang on, okay.
I'm sorry.
So you're making all these determinations for Ms. Trevizo to be transported to another facility for treatment, correct?
Correct.
Okay. And so you said you didn't want to speak with her or about this baby until law enforcement had arrived, right?
Correct.
Did law enforcement arrive?
Yes.
Okay. And were you able to inform or speak with Ms. Trevizo about this baby?
Yes. I went into the room with a nurse, and then I believe there were two officers, and I informed her that we had found a dead baby in the bathroom.
Okay. And did Ms. Trevizo make any statements about this baby?
Yes.
What did she say?
It just came out of me and wasn't moving, so I put it in the trash can.
Okay. It just came out of me, it wasn't moving, and I put it in the trash can. Was there anything else that she said about the baby or the situation?
I can't recall.
Okay.
I think I felt that it was not my job to I wanted her to understand the plan of care, which was she needed to be transferred
Okay.
to make sure she didn't have a postpartum complication, and therefore I do need her consent for that.
Okay. So you
And so I wanted,
discussing the transfer and giving her that information when these statements were made to you.
that's correct. And then the officers were present, and I wasn't present for the further communications. The patient's mother was present, and she began yelling, "I knew it, I knew it."
Objection to the hearsay.
Sustained.
Without telling us what anyone else said, Dr. Moses. So
Apologies.
after this contact with Ms. Trevizo, you said you weren't present for anything with the officers. So once you got her transfer situated, was that the last contact you had with Ms. Trevizo that day?
I believe so.
All right. I don't have any further questions. I'll pass the witness.
Mr. Mitchell.
Thank you, Your Honor. Where's the best place here, Judge?
I think this area, just in general. This is the mic here, so she'll be able to hear you from there.
Good. Doctor, help me learn to pronounce your last name properly.
Vasquez?
Vasquez. All right, Doctor, you were on a contract with Artesia General Hospital. Is that emergency to do ER work for them? Is that correct?
Yes, sir.
And as I understand it, this patient, and I'll refer to her as Alexee, came in to Artesia General Hospital into the emergency room at approximately 5 minutes after midnight. Is that correct?
I don't have access to the records, so I'll have to trust you on the timing.
Sure. And there was an initial assessment of complaints of low back pain, had cheerleading practice, has abdominal pain, and the notes indicate exam of abdomen, soft, non-extended, mild tenderness along both lateral aspects of abdomen. Were those your notes?
Yes, sir.
So you did examine her abdomen.
Yes, sir.
And would that have been done almost immediately after she came into the emergency room?
At the time of the initial evaluation, yes.
All right. And there's a lot more to that, but I'm just getting to specific issues of the day. And then at 18 minutes after midnight, I believe medication given via IV of acetaminophen and, help me with the pronunciation, cyclobenzaprine. Does that make
Correct.
sense?
Yes.
All right. And then at 28 minutes after midnight, medication was given of sodium chloride, Zofran, morphine, and ketorolac. Does that make sense?
Yes.
All right. So, and you're the only one in the emergency room, since you were the on-call doctor, that could have ordered that medication be given. Am I correct about that?
That's correct.
All right. And from the records that we've looked at, their lab tests were ordered at 28 minutes after midnight to 30 minutes after midnight. In other words, I'm not sure how your computer system works to order those, but I assume you ordered them and they were taken or collected by 30 minutes after midnight. Does that make sense? Within 2 minutes after you order them, they're collected.
I'm not sure I understand the question.
Well, I'm just asking if that was the next thing that happened in the care of this patient.
I think so, yeah.
And I want to be very fair with you, so I'm going to read this note, this hospital note, to you. and I'll use the words that are on the note. PREG, preg, serum, SERUM, ordered at 0028, collected at 0030, received at 0031, and reported at 0051, RN with positive A. I mean, with positive A, not RN. Does that mean that the blood tests were sent, were ordered, collected, received, and by 51 minutes after midnight, the lab had reported that she was pregnant?
Yeah, they would have reported it into the computer system.
Right. And we discussed with Chris Sanchez, one of the RNs that was on duty that night, the triage nurse. I assume at Artesia you have computerized systems that at the nurse's station or in your office you would have received that report. Am I correct about that?
Yeah, you have to, either the lab would call, and I just don't recall in this case if they gave us a verbal notification or not, and then you would have to go into the system to retrieve the result.
Right. And once that occurred, prior to her going to the bathroom and coming out of the bathroom, did you ever tell the patient, your patient, that she was pregnant?
I'm sorry, sir. Could you ask that one more time?
I certainly shall. Thank you. Doctor, after the lab report comes through at 51 minutes after midnight, indicating that she's pregnant, and prior to the time that she went to the restroom, did you tell the patient that she was pregnant?
No.
All right. And then, according to the videotape that's been introduced in this courtroom, and according to the notes, at 1:39, or military time 1039, Alexee enters the bathroom in the hallway of the ER at Artesia General Hospital. All right? Does that make sense?
I just don't know if, I know she went to the bathroom when I first saw her. Are you trying to say that she came out and went back in?
No, I'm not. I'm just saying that at one point in time she went to the bathroom where the allegation is that she, when she went to the bathroom, she delivered a baby. She had a baby. And I assume that's what we're all talking about here. Is that right?
I'm sorry, what's the question?
Well, the question was, here's the point. If you look at the videotape in this case of the hallway in the emergency room, at 1:39 is when she goes to the bathroom. Did you actually see her go to the bathroom? Go down the hall to go into the door to the bathroom?
No, I did not.
Now, prior to her going into that room,
At on the second event, at 1:39, no, I did not see that.
well, let me help you out here, doctor, because I know that you or somebody ordered a UA, and she went to the bathroom to try to do that UA. That was long before this, and that you did not get a UA and you did a blood test. That's what the records are indicating. Correct? Does that make sense now?
I don't really understand what you're at. What are you asking me?
I'm asking you if you or somebody else, let's do it this way. I'm asking you if you or somebody else ordered a urinalysis test, ask her to go to the bathroom and fill a cup.
I ordered a urinalysis test, yes.
All right. Did you see her attempt to fulfill that request?
Well, I didn't go to the bathroom with her.
No, that's not what I'm asking. Did she come back with any urine in the cup?
I think I don't recall, no. I mean, I can't tell you with certainty because I just can't remember.
Okay. And then, now I'm talking about this, the second time that she would have gone to the bathroom, which was at 1:39 in the morning, a.m. And this is the time that everybody in the courtroom has been talking about and hearing about. Did you actually see her at that time go to the bathroom?
No.
Prior, and I've asked you already, I'm not going to ask it again, but and you indicated that at some point in time, ER staff checks on her. Is that right?
Well, I asked where she was, and I was told she was in the bathroom.
All right. And, Doctor, are you telling us that when she came out of the bathroom, you escorted her to her room?
Yes, I am telling you that.
And did you, after she was in the treatment room, or whatever you call it there, after she's been in the bathroom, did a nurse help her remove her clothing and get into a hospital gown?
I don't recall.
Okay. When you conducted later on an examination, was she in a hospital gown?
Yes.
And if the medical records indicate that at 2:02 is when you, is the first mention of a transvaginal ultrasound ordered after post-pregnancy, does that make sense to you?
Does what make sense to me?
That you ordered a transvaginal ultrasound.
Yes.
But you guys didn't have the equipment to do one. Is that fair?
That's correct.
So you're limited as to what you could do with the doctor by the equipment that you had available.
That's correct.
And it's only after that, when you're working with your patient, Alexee, that then you get notice that they found a deceased baby in the bathroom.
That's correct.
All right, I think I've got it down. And you gave the time of death of the infant as 2:38.
Okay.
Well,
I don't have access to the records. I can't recall the time, but if that's what I documented, then that's what I did.
Okay. Doctor, was she your patient?
Yes.
Did any other doctor treat her at Artesia General Hospital?
Not on that occasion.
Okay. Was there a point in time when you were concerned after the initial study and you got the initial vitals, or whoever got them for you, you looked at them, with the patient's heart rate?
Yes.
Okay. Once you learned and the nurse learned that she was actually tested positive for being pregnant, am I correct that Artesia General doesn't have an OB ward or an OB floor?
That's correct.
And anybody, you have to refer all the patients that are, well, sometimes they have a baby anyway, but you normally refer them to another hospital? Is that what happens?
Well, depends on the situation, sir.
Yes.
So, if a patient is going to deliver a baby, then...
Doctor, there's an objection, standing objection.
No, I'm going to object to this time for relevance. I've kind of bit my tongue a little bit, but we're getting into things that don't have any relevance to the issue at hand here, whether or not
Judge, I'll
there's
move it
an
on.
OBGYN.
Okay, for the record, it's sustained. You may continue.
Yeah, I'll move it on. fact, I have nothing further of the doctor. Thank you.
Anything further?
No, Your Honor. She may be released.
Before I release you, I do have just two questions for clarification, Doctor. Number one, you said you didn't see the defendant, Ms. Trevizo, going to the bathroom. Were you inspecting, or were you conducting an examination when at 1:39 she went to the bathroom? Were you in the process of conducting an examination when she told you? Because there was a little bit of confusion there for whether you were in the middle of an examination when she went to the bathroom.
So, and I apologize for any confusion, but the best I can tell you is that when I was initially evaluating her, she left during the evaluation to go to the bathroom. I then did not see her. My desk where we sit and work is not in a place where it would be easy to know if the patient was coming and going from the bathroom. So I have to rely upon what's documented in the record as to the fact that she then went back to the bathroom at 1:39. I did not see the second time. And I never saw her physically enter. I saw her get up and say, I've got to go to the bathroom.
And then my second question is, you mentioned that there was some discussion about her telling you that she was not pregnant and that she was having her regular period. When she said that to you, is my understanding that you did not inform her at that point that she was pregnant?
Well, I didn't have the result at that time.
Okay.
I told her after, when I was at the time we got her back in the room and said, your test is positive, we need more tests to stabilize you.
So there was a statement to her that her test was positive, or was there no statements to her made before this alleged incident that occurred in the bathroom? When she went to the bathroom, was there any statements made to her of that nature?
By myself, no. I was waiting for the number level, because if that number was high or if that number was low, really changed the direction that we would go in terms of diagnostic path. And so I don't know if someone else told her, but I did not tell her of the positive test until after we got her out of the bathroom.
And I thank you, Doctor. I just needed a little bit of clarification on that. If there's any questions from either party regarding my questions, you may ask. If not, the doctor may be released from subpoena.
No, you cleared it up. Thank you.
Okay, Doctor, you've been released from subpoena. What that basically means is you're not going to be called back as a witness. You are free to go. You are not going to be required to be on call to come back and testify. Thank you, Doctor.
Thank you.
State may call their next witness.
Your Honor, the state will call Rick Lehman.
Yes.
She said she was coming. She said she was coming.
Good afternoon, sir. I swore in everybody at once, but because we are bringing in people one at a time, I'd just like to confirm for the record, you were sworn in as part of that group, correct? Yes. Okay, thank you. You may grab a seat.
I think he's in Sorry.
You may proceed.
Sir, please state your name for the record.
My name is Richard Wiedemann.
And, Mr. Wiedemann, how are you employed?
I'm employed by the Office of the Medical Investigator. I'm a senior deputy medical investigator.
Senior Deputy Medical Investigator, how long have you been working with
A little over 20 years.
And what are your duties or what is your role with the hospital?
To respond to and investigate unexpected deaths.
How do you get notified that your assistance is needed?
Either notified by the hospital or law enforcement.
And then from there you go where they are to...
Proceed to where the death occurred.
Right. I'm going to take you back to January 27th of 2023. When you
Yes.
And did you get summons to the Artesia General Hospital?
Right. I was notified by Artesia Police Dispatch and notified of the death at the hospital.
So Artesia Police Dispatch notified you, and you went to the hospital?
Correct.
And what did you observe, or what observations did you make when you arrived at the Artesia General Hospital?
Initially met with law enforcement, Detective Barnabas Gonzalez with Artesia Police Department. He gave me a brief report, went into the trauma room, I believe it was trauma room 2, and observed the decedent.
And what observations did you make about the decedent initially?
Was on the exam table on an absorbent pad. Umbilical cord had been severed. The examined did not see any obvious signs of trauma. Also, there was my brief examination, the skin appeared somewhat mottled on the chest with purple mottling on it, and there was no rigor mortis present. The muscles weren't rigid, and seemed to be a fully formed, full-term, my opinion, excuse me, I'm not a doctor, I'm not a physician, but appeared to be a full-term pregnancy.
So you said there was purple mottling. Can you tell us a little bit of what that means?
Just there were blotches on the skin.
And there was no rigor, so the muscles of the baby were not rigid.
Correct.
What do these things, or do these two things, these observations, tell you anything about death or anything like that?
For the rigor mortis gives an indication a little bit as to how long an individual had been dead. It's not like CSI where you can tell down to the minute or anything. Basically, someone is recently dead, someone's been dead a long time, someone's been dead a very long time. And I'm sorry if you need more details as far as what those times are. I mean, okay.
That helps answer the question. So did you have an opinion about what you observed, if it was recently?
It, to me, appeared to be a recent death.
So how do you begin your investigation? I mean, obviously you arrived, but what are your next steps?
As I talked with law enforcement, got their report, talked with hospital staff, got their information and for the report, and then made observations, took photos of the decedent.
Observations, photos of the decedent, and what's your next step once you take those photos of the decedent?
When I was completely, also observed the material that was surrounding the decedent. It was material that reportedly had been found in a plastic bag with the decedent, and the trash can that with the separate bag that reportedly were what I was told where the decedent came from. I said by my arrival the decedent was on the exam table. So.
All right. I'm going to show you, Mr. Woodman, what's been entered as State's Exhibits 5 through 18. Unfortunately.
You may.
Yes, ma'am.
Do you recognize these photographs?
I believe these are from law enforcement. I don't think these were my photos because I did not go to these. I recognize the scene though. From
Can you accurately depict what you saw?
Yes.
The baby, whether it was with the baby.
Yes, ma'am.
The last few pictures in that stack are of orange tags.
Right.
Do you recognize those?
Yes. The one is an armband that I placed around the decedent's wrist.
Okay, what is that?
15.
So 15 is an armband placed around
Right.
his wrist.
That has, at the time we did not have a name, so it's John Doe, or Baby Doe with John in parentheses. The Eddy County, my initial last name, my deputy number 8.36, and the date. Birth date and death date, the same. And the other orange tag is a seal provided, the armband also provided by medical investigator's office. The seal, it's like a zip tie in a way. It's once you pull it through, you can't undo it. So it has the flat part that basically an evidence seal. And so once it's closed, the zipper pulls on the body bag have two rounded openings on each one. They slide together, leaving a hole. It goes through the four pieces there and then loops back around and seals through the tag. So once it's pulled tight, it can't be undone. They have a unique number on the tags, in this case 49905. When I call in my report, as every case that field deputy investigator investigates has to be called into Albuquerque, I report that number for the seal. That number is told to the transporter, and the transporter, somebody from the funeral home, in this case Turpinning and Son in Artesia, picks up the body in the sealed body bag. The transporter, when they come down, know what the seal number is. If it doesn't match, they're not going to pick it up. When it gets to Albuquerque, it's checked to make sure it's matched and to make sure the seal hasn't been tampered with, to make sure that any evidence inside has not been tampered with.
And did you follow this process with Baby John Doe, the seal of the body bag?
Yes, ma'am. It's my handwriting, last name on the tag Doe, and then Baby with John in parentheses, and then the date it was sealed, which happened to be the date of death also. But for legal reasons, it's the date the bag is sealed. And then on the back, more information, my deputy number, name, and the Eddy County date of birth, which would go on any of the seals.
Mr. Friedman, what goes into the body bag? So in this instance, there are a number of things surrounding Baby John Doe.
Right.
Did all of the contents of that gurney on top of the gurney go into the bag with him?
Yes, the bag with paper towels, other things that were in it. The umbilical cord, of course, still was attached. The severed umbilical cord went into the bag. And the bag was an adult-sized bag. They don't issue the infant sizes anymore. So had to fold it in half and tape it so it would secure the remains.
So once you collect, seal, and get everything ready for transport, what do you do next in your process?
Call the funeral home to arrange for transport. We don't have morgues in Eddy County. Not Albuquerque, excuse me, Las Cruces, cities like that do. We do not. So the funeral homes are morgues. Called Turpinning and Son. They arrived, they picked up the sealed body bag to hold in refrigeration until the transporter from Roswell would come down to take the decedent to Albuquerque for an autopsy.
done to the funeral home, do you have any further contact with the deceased or the dad?
No. At that point, then I've phoned me in my report to Albuquerque, and then they put that into a system. And then once I got home, we don't have offices. We just work out of our homes. I did the report online and submitted that.
And do you, Mr. Regan, do you make any findings, cause of death, manner of death, anything like that?
I do not. The pathologist in Albuquerque does that.
That's all the questions I have to share.
Mr. Mitchell?
Thank you. Just a couple of questions about your report and some of the things that you put in your report. This report is given to the doctors at the Office of the Medical Investigator in Albuquerque, is that correct?
Yes, sir.
And one of the things I'm concerned here, or asking you about, is this. She stated she needed to use the bathroom and took a tampon in with her. Where did you get that information?
From the officers.
From the
From
police officers?
Detective Gonzalez and or from the hospital staff.
Okay. And you, in your report, indicate that you did not know what happened with the placenta. Is that correct?
At the time, part of why she was transported to Roswell was that they did not find the placenta, so it appeared she had not delivered.
And then you make this statement: hospital staff reported that decedent, meaning the baby, had been cleaned up prior to being found. There were bloody paper towels in the trash bag with the decedent. That was your impression as well, is that correct? That the baby had been...
The baby was not bloody as a normal would happen after a birth.
As if somebody had tried to clean the baby.
Right.
And you knew it wasn't the nursing staff or anybody else at the hospital.
All I was going by was what I was told, sir.
You got it. All right. Thank you. I have nothing further, Your Honor. Pass the witness.
May this witness be released from subpoena?
Yes, sir.
He may.
Sir, you've been released from subpoena. What that basically means is you are not going to be called back as a witness in this matter. You are free to return home or go about your day.
Thank you very
sir.
much.
Statement
Your
caller
Honor, do you
next.
think we might be able to have a 10-minute recess?
Yes, that'll be fine. No problem with a 10-minute recess. It's currently 5:27. Let's go ahead and take it. Let's make it 13. Just make it an easy, easy opportunity. So it's 5:27 now. We'll reconvene at 5:40.
Thank you, Judge.
You in, but I'm asking every witness before we proceed. Do you recall being sworn in?
Yes, I do.
Okay. And Ms. Gonzalez, as we had the issue with the last witness, you're welcome to come up to the bench to conduct this examination.
And then, if my understanding is correct, I'm going to stipulate that Dr. Schultz can testify and render an opinion as an expert in pathology.
That's correct.
Okay. The court will find that Dr. Shinost is an expert in pathology and can render opinion based on our expert qualifications. You may.
Ma'am, if you'll please state your name for the record.
My name is Dr. Harley Shinist.
Shinist. I'm sorry about the mispronunciation.
Oh, that's okay.
What do you do for a living?
I am a forensic pathology fellow.
And where are you currently employed?
The University of New Mexico and the Office of Medical Investigator in Albuquerque.
And what is your job title?
So I'm a forensic pathology fellow.
Dr. Shinist, I'm going to take you, draw your attention to an autopsy that you performed And it will be on case number 2023-00669. Are you familiar with the case to which I'm referring?
Yes, I am.
Okay. And did you perform an autopsy on baby John Doe?
Yes, I did.
Okay. What date did you perform that autopsy?
Is it okay if I refer to my report for that?
Would that refresh your recollection?
Yes.
I wonder if she may refer to her report.
Any objection?
I have no objection. In fact, I think that's wise. I have no objection.
You may do so, ma'am.
Okay. The autopsy was that I performed was on January 28th, 2023.
No, Dr. Shanos, when you receive a decedent for autopsy, how do you begin your process?
So the first thing that I do is I receive information about the scene investigation from our scene investigators, and so I get kind of the preliminary story of how things are currently known of what happens, and from there we triage whether we're going to do a full autopsy, which in this case we did, or another type of examination. A CT scan, a computed tomography scan, is performed on most of our decedents in our office, and we also look at that CT as we're hearing information from the investigators to determine what type of examination we're going to perform.
Okay. And so, did you receive all that information that you needed for this autopsy?
I did receive information for this autopsy.
Okay. And so, once you've gotten that, you've reviewed it, what's your next step in your process?
So then we go on to actually perform the examination. And so we start with an external examination, which looks at the outside of the body. We detail, if there's any medical intervention, which in this case there was not. We look at if there's any external injuries or any findings, as well as just standard things that we look at externally, like hair and eye color, etc.
Okay. So you said you determined if there was medical interventions, and in this case, there were none that you could determine? Or some?
That's correct.
Okay. You then do an external examination for injuries. Did you find any type of injuries to baby John Doe?
No, I did not find any injuries.
Okay. So once that is completed, then how do you proceed?
Then we perform the internal examination. We open the body and we take our ancillary tests. So we might take cultures, which we did in this case. We might take blood or tissue for toxicology, which we also did in this case. Bile for a metabolic study. We collect all of our additional ancillary materials, and then we examine the organs. We remove them from the body and we examine them both as they connect to other organs, and then we disconnect them and examine each organ individually as well.
All right. So, Doctor, I want to talk with you about the specific portions of that which you just described. In your report, or before we go that far, once you've completed your examination and make your findings, do you complete a report?
Yes. Once we receive all of our ancillary testing back, we do complete a final autopsy report.
Okay. And I'm going to put up what I'm marking on State's Exhibit 19 for purposes of identification. If I may.
You may.
Dr. Shadows, please tell me if you can.
I'm not seeing anything.
Sorry, give me 1 second. I looked the wrong. what I've just put up on the screen?
Yes.
Do you recognize State's Exhibit 19?
Yes.
What is it?
This is our autopsy report for this case.
Okay. Does this report have your signature fixed?
It does.
And I'm going to kind of scroll through and the pages, 7 pages. Does this look to be the report that you drafted for this case?
Yes, it does.
Your Honor, I'd like to move States 19 into evidence.
Any objection?
I'm sorry, say it again.
States 19 into evidence.
Is 19 your report?
Our question is primary, you just had an objection.
State's Exhibit 19 will be admitted into evidence. Thank you.
So, Dr. Sterner, so I'm going to talk with you about some specific areas of the report that you drafted in this report. And you already stated that there were no external injuries that you were able to see. Internally, were there any injuries that you found or any defects that you found in baby John Doe?
There were no injuries.
You make a couple of findings in your report. One, the first of which is that the lungs in baby John Doe were aerated. Can you explain that for the court, please?
Sure. So this is something that we initially saw on our CT scan that we performed and looked at in the morning. We were able to see air within the lung fields on the CT. And then when we performed our autopsy, they also appeared aerated at that point. However, the CT findings are more specific for that air.
So, what does that finding mean? You said it and I missed it.
So that finding, in the absence of decomposition and resuscitative efforts, that finding indicates that breaths were taken.
Okay. And you already said that there were no, or to your knowledge, there were no resuscitation efforts. And you said absent from decomposition. Did you find any decomposition in baby John Doe when you received him?
He had no changes of decomposition.
So you said based on that, it's evidence that he took a breath or breathed after he was born.
That's correct.
Okay. There you also note that there was air in the stomach of baby John Doe. Can you expound on that first, please?
Yeah, so the air in the stomach, again, was something that we noted on our CT scan, and again indicates that he was alive at the time of birth and was breathing, and essentially the air gets into the stomach by gulping the air.
All right. You further found that the adrenal glands had some findings. Can you explain that first, please?
Sure. We found adrenal hemorrhage on our microscopy slide, so under the microscope. It was not evident grossly or at the time of autopsy, but we take sections to look at under the microscope as well. And under the microscope there was some adrenal hemorrhage, which is a really non-specific finding, but can be seen in cases of hypoxia.
Okay. So you said it's a non-specific finding. What does that mean?
So non-specific just means it can be seen in other things as well. So you could see adrenal hemorrhage in a variety of different things, including injuries, which he did not have. It can kind of be seen as just a stress response in some neonates. And so it doesn't necessarily indicate specifically hypoxia, but with the other findings in this case, it's supportive of hypoxia.
Okay, so with the air in the lungs, the air in the stomach, or the lungs aerated and the air in the stomach, this finding in the adrenal glands supports the hypoxia in baby John Doe.
as well as, the circumstances in which he was found that supports the hypoxia.
Okay. So the being in a bag and all that information that you gained from the investigation.
Correct.
Okay. And can you tell us what hypoxia means?
So hypoxia is a lack of air.
There was also a finding or a note that there was non-specific vascular congestion. Can you explain that for us, please?
Sure. So this was on our neuropathology examination, which I personally reviewed and was also reviewed by one of our neuropathologists. And it's another one of those non-specific findings, so it can be seen in many things. But in this case, the vascular congestion is consistent with hypoxia.
So with everything, the totality of the circumstances, it also supports the hypoxia.
That's correct.
Dr. Shinos, were you able to determine a cause and manner of death of baby John Doe?
Yes, we were.
Okay. And what was the cause of death for baby John Doe?
So the cause of death was entrapment.
What is entrapment?
So entrapment is when a person is in an airtight or relatively airtight container, in this case the plastic bag, and they consume all of the available oxygen within that container, and then there's no longer enough oxygen to support life.
So entrapment, and how about the manner of death?
The manner of death was homicide.
So with everything that you performed, all of the examinations and studies of baby John Doe, was there any other injuries or defects that you determined could have or did cause this entrapment?
He had no other injuries or defects.
Thank you, Dr. Shinos. I don't have any further questions.
Mr. Mitchell.
Thank you. Doctor, did you review the lab reports from NMS?
Yes, I did.
And you noted in the heart blood morphine of 19, what is that, nanograms per milliliter?
Yes.
And is that phenethylamine, 420 nanograms per milliliter?
The phentermine, yes.
Phentermine, thank you. And phentermine is something that we see people take for weight loss or to slow, or not weight loss, but suppression of appetite?
That's what it's commonly used for, correct.
Okay, and the morphine, did you review the medical records in this case?
I did not have access to the mother's medical records in this case, and the decedent did not have any medical records that we were provided with.
Would you be surprised to find that she was given morphine at the hospital?
No.
Okay. Now, did you take a look at SLD's report?
For the cultures?
Yes.
Yes.
Is it correct that they found E. coli?
I would have
Hold up.
to
We've got an
refer to the
objection.
report.
We'll have an objection. Go ahead, ma'am.
Your Honor, there's been no information that this is drafted by Dr. Shinos or that she has knowledge of the examinations or testing for the virus.
Mr. Mitchell, your response?
I'll ask her. Let me ask her that question.
All right.
Doctor, are you familiar with that report?
Yes.
And I assume you know how to read it.
Yes.
And I assume you know what they're talking about when they're speaking of E. coli and Linococcus species, etc. Is that correct?
Yes.
All right.
Yes, I do.
All right. And I wanted to go through that with you because it relates to...
Sorry.
Yes.
I'm going to bring you my objection. The knowledge and the ability to read someone else's findings or report is non-admissible. It's a form of hearsay. Basically, he's trying to get in a report without the author, without knowing what tests were performed, how they were performed, etc., when they were performed.
What's your response, Mr. Mitchell?
My response is this is done in the ordinary course of business by a forensic pathologist as part of their studies, as part of the information they have to make determinations. It's no different than what the state just did when she talked about having a neuro, and I don't know if it was a neurologist or whoever they had at OMI look at it as well, and look at the same charts and confer with them. It's no different. This is all part of forensic pathology. You have to know what the toxicology reports come back and in order to reach certain conclusions.
And Ms. Gonzalez?
And she has, and just to conclude that argument, Your Honor, the doctor indicates she knows how to read it, she knows what they're talking about. It's part of her work.
Your Honor, my objection is just that we're trying to get someone else's work in through someone who didn't do that. I didn't admit anything from a neuropathologist. There is evidence of that, but I didn't seek to admit it because the neuropathologist isn't here. So I would say there's no foundation, there's no authentication, and it's not the person who did the testing.
In regards to this objection to hearsay, Mr. Mitchell's, and correct me if I'm wrong, you're citing that this is an exception to hearsay under 11802, a record of regularly conducted activity. I don't believe it's been established that this is in fact a record of regularly conducted activity, and the objection will be sustained.
And Your Honor, I would just bring up that there's no custodian who's present of that record. The author is not here. The SOB lab who holds that record is not here.
Well, the objection is sustained. Mr. Mitchell, you
Thank you, Your Honor. Doctor, do you regularly get, just out of curiosity, do you regularly send off information to laboratories, whether it's heart blood or whether or not it's other specimens, to two different laboratories for reports, SLD and NMS?
Yes, we do.
All right. And just out of curiosity, did you get a request for additional specimens from them?
They did not request any specimens from us.
No, that's not what I meant. Did they advise you that you should consider collecting a new specimen?
No, they did not.
Okay. Now let's talk about the mechanism of injury. And I notice you referred to a plastic bag or container, that's because that's the information you received to determine the mechanism of injury?
So I did receive that information, but we also received the plastic bag with the decedent.
Right. And the plastic bag was open at the time you received it, is that correct?
It had been opened at the time we received it, yes.
All right. So you don't know yourself what the condition of the plastic bag was earlier, do you?
No, I was relying on reports from our investigator and the law enforcement report for that.
Exactly. Now, when we talk about entrapment, we can talk about there being other non-homicidal type entrapments. Is that fair?
Yes.
In other words, other mechanisms that may cut off breathing.
Yes.
Now, in this case, I know you looked at the umbilical cord, but did you make note that the umbilicus in this case was very long?
I would have to refer to my report to refresh myself on that.
Please do.
We measured the attached umbilical cord at 63 centimeters in length.
All right. Well, I appreciate that, but that doesn't help us lay people. Does that mean it's abnormally long, short? What does it mean for a baby of 18 inches and 5 pounds?
So the length of an umbilical cord can vary. I would say this is probably a little on the long side, but I wouldn't say it's excessively long.
And entrapment can occur because of issues with the umbilical cord. Is that correct?
Asphyxia can occur because of issues with the umbilical cord, but not entrapment.
All right. Do you have any information other than the patient was in the bathroom when she had the baby? Do you have any other information as to how or where she was present or how the baby was delivered?
I do not.
Or if the baby fell somewhere? Do you have any of that information?
No.
All right. Thank you. I have nothing further at this time.
May this witness be released from subpoena?
She may.
I have something additional.
She said she had additional questions.
Dr. Sheriff, I just have a brief follow-up. Mr. Mitchell asked if the baby had fallen, but you previously testified there were no injuries or were there any injuries that would lead you to think that this baby had fallen or was dropped or anything of that nature?
No, there were no injuries to indicate that.
And one last question. Were you able to tell the age of baby John Doe?
So we did approximate his age around 38 weeks gestation, but that could be plus or minus a week or two.
Okay, plus or minus a week. Thank you. I don't have anything further.
Anything further, Mr. Mitchell?
I have nothing further. Thank
May
you.
this witness be released from subpoena, ma'am?
Yes.
Doctor, you've been released from subpoena. You are no longer required to testify in this case, so you will not be called back as a witness. You may go about your day. Thank you for your testimony today.
Thank you.
State may call their next witness.
The state will call Officer Alexander Williams.
Officer, you can come up to the witness stand. Officer, I swore in everybody all at once. I do recall swearing you in, but I'd just like to clarify for the record, you don't recall being sworn in. Yes, sir. Thank you, sir. You may address.
May I please report?
You may proceed.
This state your name for the record.
Officer Alexander Williams,
And where are you employed, Officer Williams?
or City of Artesia,
In what capacity?
police officer.
How long have you been a police officer?
Certified, maybe about 6 months now.
Officer Williams, were you employed with the Artesia Police Department on January 27, 2023?
Yes, ma'am.
Do you recall what shift you were working that day?
Yes, ma'am.
What shift?
Night shift.
Night shift?
Yes,
What time did you have?
8 p.m. to 8 a.m.
8 p.m. to 8 p.m. 8 p.m. to 8 a.m. Did you get called to the Artesia General Hospital?
Yes, ma'am.
And what was the nature of the call to Artesia General Hospital?
It was for an unintended death.
Were you the first officer to arrive to Artesia General?
I was still in FTO, so I was still training, so it was a combination between me and my sergeant. Yes, ma'am, we were the initial officers.
And who did you make contact with when you arrived?
I believe it was Heather Vasquez. I think she was the doctor or lead physician of the night.
So if you could speak up just a little bit, we're having
Yes.
trouble picking
Yeah.
up.
And without telling us what she said, did Dr. Vasquez tell you what was going on that required your presence?
Yes, ma'am.
So once you receive that information, how did you continue your investigation at the hospital?
So for in my I guess my part of the whole incident, we immediately detained Alexee, let her know that she was not free to leave, and then we called CID, which is Criminal Investigation Division, to take over the scene.
Did you go with Dr. Vasquez to speak with Alexee Trevizo?
Yes, ma'am.
Were you wearing a lapel camera or any type of video equipment when you went with Dr. Vasquez?
Yes, ma'am. I was wearing my body-worn camera.
And how does your body-worn camera work?
I guess if you're asking like how it's activated, so it's by double click. We either activate it with our emergency equipment or manually. And so in this instance, I activated it manually.
Okay, so manually. So you turned on your body-worn camera. At what point, was it as soon as you got to the hospital or when you started speaking with the
I believe, if I can recall, I believe it was as soon as we made contact with hospital staff.
So your camera stays on until it's manually turned off?
Correct. Correct. Yes, ma'am.
And once it is done recording whatever you wish it to, how does that get saved?
So we upload it through evidence.com. I mean, I guess that's the best way to describe it.
So you physically, do you have to put your camera on the dock or?
Yes, ma'am.
To put it on the dock, it uploads it to evidence.com, and then what do you do with it from there?
So we usually label it depending on the scenario. Every scenario varies. So with this one, obviously, we did, I think it's like unattended death, and then we labeled it with the case number.
Once your video is uploaded, do you have any other interaction with it? Can you take it off? Can you change it? Can you?
We can't take it off or change it. We're allowed to review the body cam just for like cases like this or just cases in general. But other than altering, the video from its original true self form, then we can't do anything beyond that.
To your knowledge, Officer Williams, was there a recording of your interaction with Alexee Trevizo?
As far as I know, yes, ma'am.
Do you see Alexee Trevizo in the courtroom? If you can you describe her for the court, please?
Yes, ma'am. She's sitting with, I guess, in the defendant stand.
Report to her, please.
Yes, ma'am. She's right there.
Does the record reflect that it identified the defendant?
The record was so recorded.
They approach and show the witness what's being marked as State's Exhibit 20 for purposes of identification.
Pardon me? How much of that are you going to play? Okay.
Judge, with all due respect, I didn't get most of this stuff before this preliminary hearing, so
Understand.
I'm trying to anticipate. I don't have the video, but I know what his report says, so go ahead.
I'm going to take a portion of this. Also, do you recognize what I just paid for your
Yes, ma'am.
Even after it depicts your interaction with hospital staff and the defendant on that day, January 27th, 2023.
From what I observed, yes, ma'am.
Your Honor, I'd like to move State's Exhibit 20 into evidence and publish a portion of the report.
Any objection?
No, Your Honor, not for the purpose of the preliminary hearing.
State's Exhibit 20 is admitted into evidence.
And this one will have audio, Your Honor. I'm going to begin at 2:26.
Be okay, one of us will be.
Who's one of you willing to be present for that conversation? You guys want to, okay, let's go right now.
So we're doing that, and then I'll make sure Leo comes out, all the other nurses and stuff are here, and I'll get you this. Hey, Maria, we can get you with that one. Mike?
Oh my gosh. That's very. Alexee, I told you about this. I just asked you, baby, to tell me the truth. It was not crying or anything. What did you do to it? Okay, stop right here. Stop. Number one priority, guys. Number one priority is she just had a baby. I don't know if she's delivered the placenta. She's bleeding significantly. Yeah. I've spoken to the obstetrician at Loveless. They want her up there as soon as possible. I just need your permission to transfer her from medical. She needs to be there. Oh, you're right. But she is a student too. No, you're right. You're right. She needs to. I'm sorry, I forgot she's 18. But you need to make sure that you're safe. I need to send you to Loveless to labor delivery. Will you please agree to that? Yes. Okay, great. I'm going to work on that. In terms, I'm sorry about this, but in terms of delivering a baby and it looked like you tried to hide it, you do have to have a police involved. And that baby's crying. It came out. Nothing. I know. But the baby's going to have to be taken for autopsy and he'll be an investigator. I'm sorry. I'm so sorry. But we need to do this correctly. And I want to be transparent with all our steps are going to be. Sarah, do you need to talk to her before we get her transferred?
Your Honor, I'm going to stop it there at 4:52. Officer Williams, does this accurately reflect the conversation that you had with the defendant that day?
Yes, ma'am. Yes, ma'am.
Mr. Mitchell?
Thank you. So as I understand it, Alexee stated the baby came out of her and she didn't know what to do. Alexee also stated the baby wasn't breathing once she birthed it. Is that correct?
Yes, sir.
And my question, officer, and I can always deal with this at a later issue, but I thought at this time you had told her sometime when you walked in the room she wasn't free to leave anymore. Is that right?
Are you talking specifically about when the camera shows or no?
No, I don't care what the camera shows.
Okay.
I'm talking about when you walked into the room, did you tell her she was being detained?
Not
she
immediately,
wasn't free
no.
to leave?
Not immediately, no.
I'm sorry?
Not immediately.
I didn't hear your answer.
Not immediately.
Oh, okay. So, but did you and the doctor say, I'm going to walk in there and I want a witness, I want the police with me, and I'm going to ask her these questions?
She more so said that she wanted us, present because of the incident. If you were able to hear from the earlier part of the body camera, she mentioned something about wanting police present for the conversation.
Yeah, I'm not being critical of y'all, sir.
No, I
I'm just
understand.
trying to get to
No,
the
I understand.
facts. The fact is, her treating physician got the police to come in when the doctor, asked a question and told her this information. Is that right?
Sorry, could you go again?
Yes. Let me move over here
Okay.
so you can hear me real clear, because I want to be very specific about this.
Okay.
Her treating physician at Artesia General Hospital, when she went to ask this question about the baby, had told police officers she wanted you with her when she went to ask that question. Is that correct?
Not necessarily that question, just the conversation.
Or when she had a conversation with her patient?
Correct. She had a conversation with the patient, yes.
All right. Did anybody stop to think that this young woman was a patient at a hospital at the time?
Objection, Your Honor.
I just want to know if you had a discussion with any
It's an improper question. One, did anybody stop to think that she was a patient? I don't think there's a question as to whether or not she was. I don't understand the question. If it's for the doctor, it should have been for the doctor.
For the record, it's sustained, Mr. Mitchell, if you wish to rephrase.
Did you have a discussion with the doctor before you went into the room to talk to this patient with your recorder going on, that the doctor wanted you there so you could record whatever the patient said?
Not necessarily.
It calls for the doctor's state of mind, that the doctor wanted you there to record. That's not said anywhere in the evidence. It's not been testified to. It's facts not evidence.
Mr. Mitchell?
Your Honor, I'm asking the question, did we have a conversation with the doctor? That's a perfectly legitimate inquiry before they went in.
That's a fine question, but not if the doctor wanted you to record. That's asking something very specific that hasn't been gotten out of
Mr. Mitchell, for purposes of this objection, I'm going to sustain. I'm going to ask you to rephrase once again.
Sure. Were you wearing your camera at the time you walked into the room?
Yes.
Were you wearing your camera when you talked to the doctor before she went into the room with you?
Yes, sir.
How many other officers went into the room with you?
Initially, just one other officer.
How many?
Just one.
Just one other, or just you?
Just one other. It was another officer, technically a sergeant.
Okay. The other information contained in your report, for example, that she was in the bathroom for 30 minutes, where did you get that information?
It was more of accumulated from hospital staff and combined with officers' interviews.
Okay. All right. Thank you. I have nothing further.
Ms. Gonzalez?
Dr. Williams, you said earlier in your testimony that you were on FTO. What is FTO?
Field training, or I guess field training officers, what FTO stands for.
Field training officer. And so you were the other officer that we saw at the onset of this video, in States Exhibit 20. Is that your training officer, FTO officer?
Yes, ma'am.
Sergeant Anaya.
Yes, ma'am.
Was he the other officer who went into the room?
Yes, ma'am.
I have nothing further for Officer Williams, Your Honor. He may be released.
Any objection, Mr. Mitchell?
No objection.
Officer, you've been released from subpoena. What that means is you're no longer required to testify in any proceeding today, any further today. You may return to duty or return home. You're no longer going to be called back as a witness. So you're required to stay here.
Awesome. Thank you.
State may call their next witness.
Your Honor, at this time, the state will rest.
Mr. Mitchell, the state has rested. Do you wish to call any witnesses?
Not at the preliminary hearing, Your Honor, but thank you for asking. I appreciate the inquiry.
At this time, does either party wish to give closing statements?
Yes, Your Honor. Your Honor, at this time, the state is going to, just for housekeeping, do you want to argue the preliminary hearing and then we can do trial detention, or do you want me to do both combo?
Let's do them both together. We'll just distinguish which argument you're making. So please start with your preliminary hearing bind-over argument and then the pretrial detention argument.
Your Honor, the state's going to ask the court to bind this case over as charged in the alternative intentional first-degree murder or in the alternative child abuse resulting in death and count 2 tampering with evidence. You've heard testimony from a number of people who were present on January 27, 2023 at the Artesia General Hospital in Artesia, New Mexico. On that date, Alexee Trevizo, the defendant, was taken to the emergency room for treatment of pain. What transpired after that was horrific. Ms. Trevizo gave birth to a 38-week, approximately, give or take a week, baby boy with no defects, no injuries, other than he suffocated in a bag that the defendant placed him in. The defendant was seen in the surveillance video for the Artesia General Hospital, running down the hall, holding her butt and, by testimony, her butt and her vagina, running to the patient bathroom where she remained for approximately 19 minutes. During this time, hospital staff, various witnesses heard the toilet flushing multiple times, heard the electronic paper towel dispenser dispense paper towels over and over. As Ms. Aragon testified, much more than a general patient in the bathroom would have done. This court has seen on the surveillance video the number of people who attempted to intervene with the defendant when she was in the bathroom. Her mother went to the bathroom 2 separate times. The nurse, Chris Sanchez, went and eventually remained standing outside of the bathroom door where she was trying to get her to come out. The doctor went to the area of the bathroom. People were asking her if she was okay, if she needed help, and stating she was having trouble having a bowel movement. She would be just another minute. It wasn't until there was the threat that they were going to open the door, and Ms. Aragon actually was at the door with a key that the defendant exited that bathroom. What was seen by all in that bathroom afterward was a bloody mess, as this court saw in State's Exhibit 2, and I have the exhibit just before one from me. It was a bloody mess that all described as having had already been cleaned up or attempted to be cleaned up. There's a large spot where there was blood in front of the toilet. Corners behind, at the wall behind the toilet, there are multiple splatters. The toilet seat has blood that is dripped and splattered on it. There are footprints leading out of the bathroom and eventually down the hallway back to the defendant's room. The amount of blood that was lost in this bathroom was concerning to everyone who saw that, concerned for the defendant, because there was no report that anything had happened to anyone else in that bathroom. Questions were asked of her if she was okay, what Chris Sanchez testified, how all this blood happened, what happened, and the defendant's response was that she was on her period. Remember, the amount of blood in State's Exhibit 2 makes that a very unlikely outcome to have splatters and drips and footprints leading down the hall that your period causes you to lose that much blood. The defendant walks away from that bathroom without any statements other than that. I'm on my period. Not I just gave birth. Not I just gave birth and put my baby in a bag. Not I just gave birth, put my baby in a bag, twisted it closed, folded it under, and put him underneath trash. Put him in with trash, under paper towels, under additional trash bags, and finally concealing everything with a fresh, clean trash can liner. None of that was told to any of the nursing staff. Not Chris Sanchez, who was treating her, not Lori Aragon, who was outside, not Dr. Vasquez, who examined her, not Elizabeth Crawford, who was her nurse as well, not her mother. No one was told about this little boy who was dying in the trash can. 19 minutes she was in that bathroom. 19 minutes after, when she exited that bathroom, another 29 minutes passed before housekeeping found this little boy. 49 total minutes elapsed from the time that Alexee Trevizo went into this bathroom, gave birth to a healthy baby boy, and he suffocated to death. Not telling a single soul. There was a call button that you could see in State's Exhibit 2 that she just needed to pull. She just needed to scream out for help to any one of the nurses who were there to assist her, and none of that happened. There were no alerts, the light didn't turn on, there were no chimes, there's no evidence that she pulled that call button. None of the many people who knocked and checked on her and heard her ask for help. Nothing, no one. The only thing that is obvious is that she tried to conceal what happened in that bathroom. There's no other explanation for what went on. There's no other rationale for what went on. In order to see the amount of blood that still remained on that floor after she gave birth and was in there for that long, cleaning up and flushing whatever she was flushing down the toilet that we don't have because it was destroyed by her flushing it down, is horrific to think of, Your Honor. It's horrific to think of this baby that took breaths, as you heard from Dr. Shanos. He took breaths enough that his lungs were aerated. He took breaths enough that there was evidence in his stomach that air had been gulped, as she described, and that he had died because the bag that he was in ran out of air. You heard from the women who found this baby, who testified about what they saw. All of the blood in the bathroom, cleaning, doing their general run-of-the-mill duties until pulling out this trash can. It's heavier than normal. Pulling back this seating clean liner and finding this baby inside. Eventually having to tear it open. Ms. Aragon testified that it was the opening of the bag containing the baby boy was twisted tightly around and folded underneath him, so that when she picked him up, the bag suctioned to his face when she removed him out of that trash can. Ms. Lewis saw his dark hair and saw him at the bottom of that trash can. By the time he was located by everyone, there was nothing in it. Mr. Halliday could not. He said his temperature, he had no heartbeat, he was not breathing, as Dr. Vasquez did the same, and there were no attempts at resuscitating this baby. Your Honor, when the defendant was confronted more than 49 minutes later, because 49 minutes is when they found the baby, it was probably another 49 minutes before law enforcement did. Alexee Trevizo said nothing to anyone about this baby in this trash can until Dr. Vasquez told her that they found a baby dead in the bathroom. And her statement was, it wasn't breathing, nothing was breathing, nothing was crying. What did you do to it? I put it in the bag. That was her response to this life. I put it in the bag. Not I checked it, not I called for help, not I needed someone to help me. I put it in the bag. It's one thing to not know what to do, it's another thing to be scared. Those are very natural responses to things that happen. It's a very unnatural response to take a baby out of your body, sever an umbilical cord from your body, and some will say because such wasn't found, nothing was found, and so we can only infer that that happened. take that baby, put him in a bag with trash, twist and tie the bag, fold that underneath, place him in the bottom, pull off 2 additional bags, crumple them up, put them on top of him, take the paper towels, crumple them up, put them on top of him, and take another bag, open it, and put it on him. All of these volitional, intentional, deliberate acts that Ms. Trevizo did to conceal what she had done, that she left this baby to die in this bag and walked out with him. Your Honor, all the evidence is present for both charges, for willful and deliberate murder, for intentional child abuse, and for the tampering with evidence. We would ask the court, at this stage, the probable cause hearing, we would ask the court to find that probable cause had been met and that this arrest charge. Oh, and for the pretrial detention, sorry. For pretrial detention, the state is going to ask that you hold Ms. Trevizo without bond for the reason that she is a danger to herself and to others. While this baby did die, he's not in the world anymore for her to harm. That's not to say that there can't or won't be another baby that she will harm. In addition, the lengths that she went to conceal what she had done is very concerning. The lengths that one will go to conceal and not get caught committing a crime makes someone a significant danger. If you're willing to do this in a business or a building with multiple people standing outside of your door, what else are you capable of doing? What else are you willing to do? I think this makes her a very dangerous person. I think a lot to circumstance her being out on the street, going about her business. After all, no one knew that she was pregnant. She told no one that she was pregnant. Perhaps she didn't know she was pregnant. But after the fact, to suffocate your baby in a bag and then hide it from everyone would be a significant threat to people and other babies that you may have in general. So now the state thinks that she does pose a threat. If you feel that pretrial detention is warranted in this matter, then that's not what you get for
Mr. Mitchell?
Thank you. Let me discuss the hearing first, and then I'll discuss what should be released. Let me begin with what has been admitted in this case. It was absolutely clear. We have a 19-year-old high school senior that goes to the only hospital in the area, Artesia General Hospital, for help, and is in the emergency room at 5 minutes after midnight, telling them of the issues that she's having. According to them, back pain, there's some mention of abdominal pain. The doctor first indicates that she refused to be examined, but then on the cross-examination has to admit that at some point in time, in that initial inquiry, she examined her abdomen and found a soft, non-extended, and mild tenderness along both lateral aspects of the abdomen. There's no pelvic exam done, but they go ahead and give this medication, including morphine, within 18 minutes of midnight and then within 28 minutes of midnight. So within just a few minutes, she's already given this powerful medication. And they order lab tests. They know at 12:51 that she is pregnant. And she's tested positive. And that's an examination from the blood, and they've identified that, and those reports have gone out. Chris Sanchez knew about it, the RN who was taking care of her. The doctor should have known about it. I'm not sure the confusion, but the doctor, when she had absolutely learned about it, but their computer system provided her that information, and since she's the caregiver for the patient, I should have had it. So let us begin with that scenario. It is 48 minutes later, between 12:51 and, based on the tape that's submitted to the court, 1:39 in the morning. 48 minutes that she's there. She's not taken to OB. She's not even undressed. She's not placed in a hospital bed. She's just there taking this medication through an IV, and they're continuing to feed this medication to her. And then, at 1:39, she enters the bathroom after a nurse went in to help her get undressed. And I unhooked from the IV, not undressed, but unhooked from the IV in the picture. And the video shows her absolutely running down the hall to the bathroom. And yet, the physician, according to the other witnesses, there at the nursing station, the nurse taking care of her is there at the nursing station. Another charge nurse is around who has helped deliver babies in the past. And all of these people watch this and lend her no assistance. 48 minutes. There's no question that at 1:40, Rosa, her mother, goes to check on her. But we don't know what happened or what was said. Rosa checks on her again at 1:49, according to the videotape that's in evidence. And it's not until 1:53 or 1:54 that the ER staff goes down to check on Alexee. No one checks, based on the film, until at least 1:52 or 1:53. And then at 1:57, she exits the bathroom. Approximately 18 minutes. And still, it's not until 2:08 that we see on another video when the ER staff starts cleaning the bathroom. So, and as I believe I asked the question about 2:38, the time of death, pronounced. Now, we've dealt with this kind of issue before, where the state and OMI come in with these different theories about things. We dealt with it in a case out of Las Cruces called Conover, in which the New Mexico Supreme Court says, wait a second, you can posit these theories, but they're not sufficient. And the doctor, the OMI doctor has to acknowledge, or the fellow has to acknowledge that she got that information from a plastic bag that was brought, that was open when they saw it, and from information that somebody gave to them. There are a number of different mechanisms that can result in a child's death or entrapment. This case is far, it's frustrating to me because I wish I had all this stuff beforehand, but that's the essence of preliminary hearings, and you've been a magistrate for a number of years, you know how this works. I've explained it to my client who probably doesn't understand what probable cause hearings are all about, or to most of the people in the audience, which are her family members. Be that as it may, I've explained it, and I understand it as a lawyer. Now, I don't see where there's any evidence of premeditation. She didn't know she was pregnant. She didn't know when she went down there. She went down because she thought she had to go to the bathroom. And she has said emphatically, time and time again, the baby did not breathe, the baby did not cry. And obviously she had birth in the bathroom. Giving birth is not necessarily a clean event. And so nobody should have been surprised by the amount of blood or anything else. My point is that you have a 19-year-old that's obviously in distress, that's on major medication, and the state's asking for first-degree murder in this case, and a bind over on that when there's no evidence of intent at all, and when there's no evidence of any type of child abuse in this case. Now, let me speak to the other issues, and that is release. Virtually with the exception of 2 or 3 people in the audience behind me. These are her parents, her father, her mother, her stepfather, her stepmother, numerous grandparents, step-grandparents coming from Odessa and Lubbock and Oklahoma, all to be here for her. An honor student at Artesia High. In cheer, and that evening, frankly, she'd been at cheer practice for 4.5 hours before. She'd made cheer practice every time they had it, which is 5 days, sometimes 6 days a week, for the entire year. It already admitted to New Mexico State University on several different scholarships. So this is somebody that doesn't have so much as a speeding ticket, ever. That's what we're dealing with here. Somebody has no criminal record. Somebody that doesn't have a day of suspension from school. Somebody that's worked hard in choir and cheer, extracurricular activities at Artesia. And no evidence, frankly, never been in a hospital for this type of situation, or in a room, or in those rooms, ever. She had a cut one time, but other than that, that was taken care of easily. We had none of this kind of involvement. Never had, and I'm saying this not for disciplinary, but for release, never had a pelvic exam before, ever. Had practiced safe sex with her boyfriend, and he's here today as well. Ironically, when I called him and talked to him, if there's anybody that's a victim, he's the father of the child. He would tell you, and he's behind me someplace, there he is, he would tell you that he wants her released. There's no reason to keep her in. So no wonder the state hasn't sent a victim's advocate out to talk to him. Because normally we hear about that from family. But this is the family behind it. Every one of them would like her released, because there's far more to this case than what the court has heard today. And I appreciate the courtesy of the court going after 5 and trying to accomplish all this. I will tell you that she's welcome to, she lives in Artesia with her mother and stepfather. She's the youngest child of 5. Certainly that's where she should go back so she can finish school. She has finals this week, and hopefully be able to graduate. The other thing is, her father in Odessa, who lives and stepmother, have told me, at certain times she can come live with them. She can live with her brother in Lubbock, and she can live with her grandparents in, say Seagraves, it's Seminole. I get them sometimes mixed up. In Seminole. She can live with other sisters. So it's not like I don't have places for her to go. And this is a family that's on the phone to me every day. So it's not like I don't have contact with everybody here. There's no indication she's a danger to anybody. Under the Supreme Court guidelines, that's the criteria. I don't know where they get this idea. I mean, I wouldn't go visit Artesia Hospital, but other than that fact. The other thing is, frankly, and Detail knows this as well, I've got to get her to a physician because there's still some ramifications from all this that need to be taken care of. Not in Artesia. I'm trying to get another doctor in a couple other communities to see her. And they will. If she's released, they're not going to come to the jail or anything, but that's another reason in this particular case. There's no reason for ankle braces, there's no reasons for bond. We've got extensive family that care about her dearly. She's never been in handcuffs until this incident, never been in jail. And the state can rant and rave about everything that happened in the bathroom, but the fact of the matter is that you have a 19-year-old taking some pretty strong medication without any assistance from the medical staff that ends up having a baby in the bathroom. In her own words, the baby never breathed, the baby never cried, the baby was dead. The evidence is that she, what we have is that she killing the baby, obviously tried to do whatever. There's no evidence that she even knew, not having been in that room, not having been in the hospital, that there's some cord that you can pull to get somebody's attention. It doesn't help you. So that's the situation she finds herself in. Absolutely not a first-degree murder case, and absolutely she should be released. There's no reason under every case that the Supreme Court's examined under the rule that she should be kept in custody. No reason for that. So I ask the court to release her. Thank you, Frank.
Gonzalez, anything further?
Thank you.
Mr. Mitchell argues that there is no deliberation or premeditation. She didn't know she was pregnant. The courts have ruled regularly, I think the definition states that premeditation doesn't have to be a lengthy statement. It is enough to weigh the consequences of your actions. And I think that the time spent in the bathroom cleaning up and hiding the evidence of the murder were enough for this defendant to think about what she had done, weigh the consequences of her action, and act, especially by the meticulous nature with which this baby was wrapped in the bag and then concealed, and the other remnants of her giving birth were attempted to be cleaned up, and her explanation, I'm on my period, and then allowing another 30 minutes to pass before allowing other people to discover this baby. So I think there is deliberation, there is premeditation, and there is intention in her actions. This baby wasn't crying. Why put it in the bag? Why twist the bag? Why place the bottom of the bag in the infant? Why put the bottom of the trash can? Why all these things, Your Honor? The jury instruction for this charge says that the deliberate intention may be inferred from all of the facts and circumstances in the killing, and there are significant and substantial facts and circumstances surrounding the killing of this baby boy. Regarding the pretrial detention, Your Honor, the rule 5409 has a number of things that the court has to consider in granting pretrial detention. One, the nature and circumstances of the offense charged, including whether or not it's a crime of violence. There's no doubt that this is a violent crime. A baby, a newborn baby suffocated to death in a bag is becoming very, very, very violent. The weight of the evidence against the defendant, we've heard the testimony and the statements of the defendant herself. So the way that this evidence is strong, see the history and characteristics of the defendant. I would not disagree that she does not have a criminal history, but to go from zero criminal history to murder, I think is very telling. As I argued before, the lengths that she went through to conceal the murder that she had done make this very specific characteristics of her, the way that she deals with things, and the manner with which other things can be dealt with by her or swept under the rug by her. See the nature and seriousness of the danger to any person or the community that would be posed by her release. As I stated earlier, no one knew about this baby, this fetus, to use legal terms. No one knew about the fetus before he was discovered in the trash can. No one knew about him when he was born, and no one knew about him being alive and being in that trash can for about 49 minutes until he was discovered by hospital staff. So I think that there is a danger to any future children she may become impregnated with in this manner. Any facts tending to indicate that the defendant may or may not commit any crime if released. There are no indications of that, Your Honor, other than I would argue the ways that she went through to conceal this case and going from no history or crimes to first-degree murder and child abuse. So, Your Honor, the state would ask the court to consider all of these things and the actual evidence in this case, not that she didn't know she was pregnant, fine. Not that Chief General Hospital didn't give her a pelvic exam, fine. It was Alexee Trevizo who gave birth in the bathroom. It was Alexee Trevizo who put that baby in a bag of trash, tampons, and other things that were stuck to his head. It was Alexee Trevizo who twisted that bag. It was Alexee Trevizo who folded it under and placed it at the bottom of the trash can. It was her alone who placed other items on top of that and then sealed it all with a clean liner so that nobody would know what had happened to what she had done to that baby. So we would ask the court to bind over his charge and to grant the charge.
Ladies and gentlemen of the audience, when I announce my decision on these two separate matters, I'm going to remind everybody that we are in court and we're not going to have any outbursts. I need to stress that any outbursts will not be tolerated by the court. Ms. Trevizo, can you please stand? Before the court are two separate issues to consider. The first issue we're going to take into consideration is whether or not the state has established probable cause to have this matter bound over for further proceedings. Now, I must stress, a probable cause hearing is different than a trial. You may have heard the term guilty beyond a reasonable doubt. You may have heard that on television or on shows, or people referred to it, or when people discuss criminal cases, that term, innocent until proven guilty. That is not the standard at a preliminary hearing. What the standard at a preliminary hearing is whether the state has established probable cause that a crime was committed and the person charged, which in this instance is you, has committed that crime. What exactly is probable cause? Well, there are guidelines in New Mexico law, including New Mexico Rule 14-8006. It is a court rule that refers to grand jury proceedings, but it also provides a definition of probable cause. And it states probable cause means the evidence presented would cause a reasonable person to believe that an offense has been committed and the accused committed the offense. There's also, this is also reiterated in the State v. Vallejos case, 1979 NMCA 089. The test at a preliminary hearing is not whether guilt is established beyond a reasonable doubt, but whether there is that degree of evidence to bring within reasonable probabilities the fact that a crime was committed by the accused. Again, we are not making a determination whether or not the defendant is guilty beyond a reasonable doubt. With that in mind, the court does believe that probable cause has been established on count one, the charge of murder. We do note that murder is, by the statute 30-2-1 reads, murder in the first degree is the killing of one human being by another without lawful justification or excuse, by any of the means with which death may be caused, by any kind of willful, deliberate, and premeditated killing. Premeditation does not have to be a long process. A deliberate intention refers to the state of mind of the defendant, and it's rarely subject to proof of by direct evidence. It often must be inferred by all the facts and circumstances presented to the court. And in this instance, again, the court would note that a decision to commit murder may be reached in a very short period of time, and that is set forth in State v. Lucero, 1975 NMSC 061. I would also note that the deliberate intent, where I quoted regarding the inference of the facts and circumstances presented, is State v. Astorga, 2015 NMSC 007. The court also finds probable cause to bind over the matter on count two, tampering with evidence. Tampering with evidence consists of destroying, changing, hiding, placing, or fabricating any physical evidence with intent to prevent the apprehension, prosecution, or conviction of any person or to throw suspicion of the commission of a crime upon another. Now, this does not mean I'm finding you guilty. This means that the case is proceeding, that the state has met their burden of establishing probable cause, and this case will continue. Your next hearing will be a pretrial hearing, as we have already conducted the arraignment before this. That now goes to our second issue, which is the issue of pretrial detention.
I'm sorry to interrupt. The question I have is about, it's charged in alternative theory. Is the
Correct.
court binding it over in alternative theory?
Yes, I apologize. Thank you for that. The court is binding over in the alternative theory as well, which is abuse of a child resulting in death. The court does also find probable cause in the alternative theory of count 1. Now, we are now going into the issue of pretrial detention. The court has reviewed, unlike the preliminary examination, which was based entirely on what was presented here, the rules of evidence applied to the hearing, a pretrial detention can, and I'm going to quote Rule 5409 here, F4, the state is required to prove by clear and convincing evidence that no release conditions will reasonably protect the safety of other persons or the community. Clear and convincing evidence, as set forth in Will of Farrell, 97 NM 383, evidence to be clear and convincing, it must instantly tilt the scales in the affirmative when weighed against the evidence in opposition and leave the fact finder's mind with the conviction that such evidence is true. So I realize now I've brought in a third standard. We talked about innocent to proven guilty beyond a reasonable doubt. Then I talked about probable cause. Now we have a third standard, which is clear and convincing evidence. Now, for a motion for pretrial detention, that is the first inquiry. Is the individual a danger to the community, or are they a danger? We also look at the individual's prior history. We also take into consideration if there are any conditions of release outside of pretrial detention that would ensure compliance with court orders, ensure your appearance to court, and ensure that the community remains safe. 5409 sets these standards, and I will start by looking at the weight of the evidence against the defendant. The court has heard the preliminary examination. The court does believe that the state has a moderately strong case based on what we've heard in the preliminary examination. Again, I'm not prejudging this case. I'm not saying that I have ruled on it. But for purpose of pretrial detention, I do believe that the weight of the evidence is moderately strong. We then go into the history and characteristics of the defendant. And at this point, the state has conceded the defendant has no prior criminal history. The court has done its own inquiry or research, and I've looked on the Odyssey system, and I see nothing on Odyssey to indicate you've ever had any criminal case in Odyssey. I've also reached out to the Artesia Municipal Court and the Carlsbad Municipal Court, and there is no history at either of those courts, including traffic citations. The nature and seriousness of the danger to any person or the community that would be posed by the defendant's release. And this is ultimately the foundation upon which the state is basing its request for pretrial detention. The criminal complaint indicated that you were found to be pregnant. Shortly thereafter, you went into the bathroom, and then this alleged incident occurred at that time. I'll note that the testimony here does seem to indicate that when you went into the bathroom, there's been no evidence that you knew you were pregnant when you went into the bathroom. Now, again, a pretrial detention hearing, we can consider out evidence that is normally considered hearsay, and on this particular hearing, the court has had the opportunity to review the instances in which the research regarding instances in which mothers have committed murder on their newborn child. And this was ironically enough unrelated to this case initially. There was another case in Lee County that had a similar charge, and there was reference to that made that this court had initially looked into that. And the court would note that a lot of this research does indicate that the two major dangers for a person in your situation who has been charged with murder of a child is danger to themselves and danger to another child if you were to become pregnant again. I did not see anything to indicate that these instances, as horrific and tragic as they are, generally portend a new pattern of criminal behavior that has been previously unseen by an individual, and that the community would be at risk based on simply the charge. And ultimately what I'm seeing here from the state is that the state is asking for pretrial detention almost solely based on the nature of the charges. And we don't even have to go into the pretrial detention rules. We can go to the 2014 case, State v. Brown, which is 2014 NMSC 038, which was also, I might note, a first-degree murder case in which the court basically says that all parties do have a constitutional right to bear bond, but more importantly, that the nature of the charges alone cannot be the basis for pretrial detention. Now, I do know that the Ferry case, which I'm bouncing between my documents here, the State v. Ferry case does address and that is 2018 NMSC 004. In paragraph 6, it does say that the nature and circumstances of a defendant conduct in the underlying charge offense may be sufficient despite other evidence to sustain the state's burden of proving by clear and convincing evidence that the defendant poses a threat to others or the community. But I don't believe that that has been established in this hearing here, that this defendant would be a threat to others or the community based on this incident that occurred. I would note that, again, with this no prior criminal record, that the court has nothing else to base it on, such as missed court dates, probation violations, or any other criminal activity. I do believe that there are less restrictive means to ensure the defendant's compliance with court orders and appearance to court than pretrial detention. So at this time, I am going to deny the request for pretrial detention. I am going to be setting the bond as follows. It will be a $100,000 unsecured appearance bond. What that means is that you're not going to have to post that $100,000. However, if you violate your conditions of release, you may be on the hook for that. The state of New Mexico may go after you for that amount. These conditions of release, this bond, this unsecured appearance bond, is going to be based on these conditions of release. Number one, I'm going to order you to attend counseling, and I'm going to say the Guidance Center of Lee County because that's the one I'm familiar with. I realize there's probably something closer, but for purposes of today's hearing, I'm going to order you to undergo counseling at the Guidance Center of Lee County or equivalent counseling program. I am going to allow you to travel within the state of New Mexico. I'm not going to place you on house arrest. I'm going to allow you to travel in the state of New Mexico and in the state of Texas. I understand that you may be a student or planning to be an upcoming student at New Mexico State University. So you will have the opportunity to attend classes at New Mexico State University. And you will be allowed to commute to this. You will be on a strict curfew, though. You are not to leave your residence or your dorm from the hours of 7 p.m. to 7 a.m. And this is going to be very important. As I mentioned, the danger that this court believes could come is to yourself and to another child if you were to become pregnant again. So this following condition of release is a little bit unusual, but it is very important that you follow through on this. You are not to have a continuing personal relationship with anyone as defined in 3311. I believe that is the correct statute. Just give me a moment here. 30-311. You are not, subsection B, you are not to have a continuing personal relationship. Now I'm going to read you that definition. Continuing personal relationship means a dating or intimate relationship. I understand you have a boyfriend. You are allowed to call him, you're allowed to FaceTime him, you're allowed to maintain your relationship in that way, but you are not to have be in the same room with him or have physical contact with him. I don't care if it's at a family event and you're all together. No continuing personal relationship. I'm going to tell you, ma'am, if the state provides a picture of you from Instagram with you and your boyfriend together, or you and any other young man together, that could qualify as a continuing personal relationship, this court will revoke your conditions of release. You are, again, I'm allowing you to travel anywhere between the state of Texas and the state of New Mexico. You are not to travel any other state. I understand you have family in Oklahoma. If you're wishing to visit them, you need to call Mr. Mitchell. He can file a motion to allow you to do that, and the court will make that determination at that time. You are to, again, maintain, you are going to be allowed to attend school. If you are in school, then you are to continue to go to class. If you are not a student at New Mexico New Mexico State University, then you are to actively seek employment. I am also going to order you to check in with ASU, the Alternative Sentencing Unit here in Eddy County. Now, if you are outside of the jurisdiction, if you relocate to Lubbock, which is not prohibited, or to Seagraves or Seminole or wherever, which is not prohibited, you have to be accepted into a complementary program or a similar program to ASU. If there is any questions whatsoever, Mr. Mitchell will file a motion regarding that. If you are a student at New Mexico State University, you are to check in with their pretrial services department in Doña Ana County, and you are to undergo pretrial services with them. I believe I've covered most of my conditions release. Oh, you're not to possess a firearm, destructive device, or other dangerous weapon. You are not to drink any alcoholic beverage. You're under the age of 21, so that's an automatic. You're not to consume any drugs, including cannabis. You are to continue this treatment. You are ordered to undergo any additional treatment or any additional counseling as ordered by ASU or recommended by ASU or your counselor. Again, the curfew is in place. You are not to have any contact with any witnesses in this case. You're not to discuss this case with any of them or discuss their testimony with any of them. You are not to violate any federal, state, or local criminal laws. Any of these violations of any of these conditions of release, I said, this case may go on for a while. You may think after 6 months or 7 months, oh, okay, you know, they won't mind if I run to California for a week. My family's going to California, or my friends are going to California. It's spring break. I'd like to go to Mexico. I promise you, if I find out of any violations, you'll be remanded. And if you want to know how long you could be waiting for this case to go to trial, just ask Mr. Mitchell how long his cases generally run. And imagine yourself in custody for that entire time. I cannot stress this enough, ma'am. You are going to be on a very short leash on this. You must follow these conditions of release. Otherwise, you will be remanded into custody. Is there anything further from the state?
Your Honor, I would just ask that she be required to notify the court if she moves of her address so that the court and we can have record of her address.
And thank you. That is a standard condition of release. You are to keep your address current with the court. And I should add, you're to maintain weekly contact with Mr. Mitchell's office. Now, sometimes he won't have much to say to you, but you still need to call him once a week. I can tell you right off the bat, I've had this happen before in cases, and this does not go well for individuals. When I call the case and I say, Mr. Mitchell, where's your client? I don't know. She's changed her number. I haven't heard from her. I've had that happen in court before, and it never ends well. You need to maintain weekly contact with your attorney. Keep your address current with us. If you do relocate to Lubbock or to another residence, you need to let this court know. You need to let Mr. Mitchell know, and once a week, keep in touch with him. And Mr. Mitchell, is there anything further on your end?
There's one thing.
Yes.
Her mother, the state, subpoenaed her for this. She's a potential witness. You've heard it. And my concern is it's her mother, and that's where she lives.
That is a valid point. I am going to somewhat modify that, but go ahead.
Your Honor, I would ask that that condition remain, and Ms. Rodriguez is on the state's witness list, and will.
Please, folks, you guys got to be. Come on, you've remained calm all this time, so don't.
She is a witness. She will be an essential witness in this matter. She was part of as the court could see through the exhibits. I understand it is the defendant's mother, but she's 19 years old. Mr. Mitchell has stated that there are many different options and opportunities for her to live elsewhere. So I would ask the court to keep that condition. I know that this is a long, stressful process. They're not to speak about this. They're not to speak about anything that goes on with the case. So I would ask the court to continue that condition.
It's not an impossible deal. We'll do whatever the court orders, and I've got plenty of family members to take care of that. But it is.
Ma'am, let me ask: are you her mother?
No. Her mother's still out in the hall.
Okay, I'm sorry. I'm going to state I am going to allow limited contact with your mother, but what this basically means is you are not allowed to discuss this case in any way, shape, or form. Your mother may want to do so. She may want to talk about testimony. She may want to talk about this case. I'm going to tell everyone in this courtroom, all of your family members, there is zero tolerance for that. If the court gets any wind that has transpired, even if your mom initiates it, this court may issue a warrant and have you remanded into custody, and you may remain in custody until this case goes to trial. So I must stress, no discussion of this case with your mother.
Your Honor, I would also ask for there to be no third-party contact As was noticed in the jail calls, there were, I'm not sure who it was, but Mom told me to tell you this, that that's also a strict condition for her.
Well, at this point, since you are allowed to have contact with your mother, you can discuss things like what you're going to do at Christmas or whatever things you wish to talk about with your mother, as long as it does not relate to this case. And that is going to mean that there's going to be no third-party communication of things related to this case to you or from you to your mother. So again, that's a very strict condition of release. Your family is here. They've all heard it. They will help enforce that, I'm hoping, because again, that's going to be on you. Even if your mother initiates a conversation, it's going to be on you if you end up being remanded into custody for having discussions about testimony with your mother. Is there anything further from any of the parties at this time?
Your Honor, the bind-over order, will the court prepare, or would you like the state to prepare?
I'm going to ask that you prepare the bind-over order, but with that being said, I'm going to prepare the pretrial detention order. We have a 3-day deadline on that. I'm going to go ahead and write that tonight, and I should have that ready by tomorrow. I am also going to prepare a release order for the detention center. My staff is left here, so I'm going to go ahead and fill that out now. And Isabel, can you go ahead and, would that be the best way to go about it, sir?
You can give me 1 hour, email it to me, either way, good.
Okay. I think we need to file stamp it. Can you scan things into Odyssey? Okay. Okay. Ms. Montes, we'll reach out to Ms. Montes and make sure we get that. But I'm going to go ahead and sign the release order. I'll give you a copy of that now. It may be slightly different from the release order that is going to be entered into Odyssey. That will have a file stamp, but I will prepare a release order at this time.
Thank you, Your Honor.
If there's nothing further, the parties may be excused at this time. Just go off record.